So welcome everybody to Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters, and we've been speaking a lot since November on trusts, and probably will continue on till payday, let's put it that way. So we've been going over a lot on the Gilbert's Law Summaries, that series of law books that is like there's different sets on contracts, torts, but the one we're looking into is called Trust, and it's Trust by Edward C. Halbach Jr., and that's Gilbert's Law Summaries. And we've been kind of using that as the basic primer for trust, and keep in mind that that's a statutory trust that this Gilbert's Law Summary is talking about. And what we really want to talk about is the private trust, which operates on the private side and is really outside the realm of the public. So everybody has that book. Get it handy, because we'll be talking probably about that. And your Black's Law 8th edition, or whatever you're using, preferably I would have an 8th, or I guess they have a 9th out. I haven't seen the 9th yet, but anyway. And also the UCC with the official comments. And people have been asking me about, which UCC to get, so for the workshop. And it's UCC. It stands for Uniform Commercial Code, and I have the 2004 edition, which is really outdated. So I would suggest that you get the latest edition that's out there. Yeah, this is 2010. Well, maybe if they haven't published a 2010 version, there's possibly a 2009, or there at least has to be a 2008, I believe. But it says official text and comments, and you need the official text and comments. And it's published by Thomson West. Thomson West is the publisher. And it includes, if I can find the ISBN number on there, the ISBN number is 0-314-11346-0. Now, I don't know what that would bring up. I haven't checked that out, but you want to get the latest edition that's out there, because this 2004 edition is really outdated. It's outmoded. Although it's the one I've been using, some things I found out has been changed in there a little bit. But I can't afford to throw mine out because I got too many notes in it. So. But anyway, we'll be coordinating to the newer one. So that, the Black's Law and the Gilbert's Law Summary is a requirement. Also, I'd like to announce, formally we announced last week on the 16th, last Saturday, the formal announcement of the Moving Titles and Commerce Workshop with a new remedy through NTT as New Trust Technology, utilizing the Moving Titles and Commerce platform, and brought to you by you-know-who, Christian Walters, your host. So I have a new website, and that website is movingtitles.com. Movingtitles.com. Please do not just do a Google search for that, because this site's too new. The search engines have not picked this up again, and it won't be displayed in the search engine. You need to type in your browser, movingtitles.com, and it'll take you directly to the web page. Some people say they can't find it. It's up there. You can't find it. It's because you're not doing it right. Type into your browser, movingtitles.com, and it'll take you right to the site. We have a single page up there, and we have an explanation about the Moving Titles and Commerce Workshop. And I just got done revising it again from what it was the other week, and now there's some additional information on there and some corrections to make it a little more clear what a workshop is and what the price is. But at present, this website is still under construction, and we are making every effort to grant you an entire spectrum of knowledge and trust as soon as possible. But at this point, we can provide you with information regarding the Moving Titles and Commerce Workshop, utilizing the NTT as new trust technology. But the whole emphasis of this site is going to be on how trusts apply as a new remedy. So if this topic certainly interests you, please keep checking back on this site later, because there's going to be continually updates on that. In the meantime, you can reach me at my email, which is christian@movingtitles.com. christian@movingtitles.com. And all this information is on the website. So type in movingtitles.com in your browser and just go to the website. Also, all my other email addresses are still up and functioning. Any that you've been sending to previously still are working. So I'm looking forward to hearing from you. If you're not familiar with NTT and Moving Titles and Commerce platform, and your first contact with us is online, then, well, we would be pleased to hear from you. So please let us know what your questions are, and I'll be more than happy to get the answers to you. But in brief, the announcing of the Moving Titles Commerce Workshop, it's a private workshop with a new remedy through NTT as New Trust Technology. I've been speaking about the Moving Titles platform on the show, Money, Banking, and Trust by Moving Titles and Commerce, for well over almost going into 2 years now. And there's been many requests for further education on this topic, and we've reached a point in time for an expanded understanding of the moving titles platform, including the explosive new remedy technology, NTT, as new trust technology. So I'm pleased to announce this workshop, which I formally announced last week, and we're kind of like a summarize of that. So with this quantum leap technology, I've released this workshop entitled Moving Titles in Commerce Workshop as a working platform for building the revolutionary technology NTT as new trust technology. But first, let's go back. What is Moving Titles Platform? In order to help people understand the confusing A through Z concepts out there today in this arena, I've come up with a simplified way of understanding it all, a simplified way of looking at everything as a title in the public that represents the real thing in the private. And that title is moved through an understanding of the technology used to move the title from one account to another. And this technology recognition is the Moving Titles Platform. Now, what is NTT as New Trust Technology? So while studying trust, because trust was one of the main words in the program show, title to the show, Money, Banking, and Trust. So I've been talking about money, I've been talking about banking, I've been talking about trust. And while studying about trust to bring up new content for the show, I've recognized how powerful the secret implementation of trust in their use. And a result of this has been emerging the revolutionary technology NTT as New Trust Technology. Now, trusts have been around for a long time, since before 1367. So the recognition of trust as the straw man is relatively new, but the particular application of the straw man trust and terminating the straw man trust along with the claiming of the disbursement of the huge assets held within the trust account is a quantum leap in technology. And also how trusts are used to enslave those who do not know or understand the trust or deceiving the people into volunteering as slaves by the lack of understanding. The secret is that no party in a trust needs to know or understand that a trust is being formed. And once you get that concept down, that's truly amazing. Now, that's how they've been hypothecating you. That's how they've really been pledging you. And we all thought it was admiralty, and here we all thought it was debtor-creditor relationship, UCC, and we're going to do discharges and set off. And no, here all along, it's 180 degrees from that. It's the opposite direction. It's all about trust. So knowing who you are is not being a secured party creditor through a debtor-creditor relationship, but only first through a trust relationship as grantor. It is knowing who you are as the grantor, not knowing that you're a secured party creditor. It's knowing who you are as grantor. This is the revolutionary concept. And we didn't know and understand a trust in order to act in expressing and claiming a trust by proving a trust. And we need to go to the next level then and learn how to administer the trust. And if we don't, we'll be right back volunteering into slavery by commingling the private trust with the public again. So the Moving Titles in Commerce workshop will be a work in progress where we together address these issues. And people attending the Moving Titles in Commerce workshop will assemble their own documents, word by word, line by line, paragraph by paragraph, so that they know and understand them. It is a workshop where they work and have access to detailed, more in-depth information through me and my knowledge and understanding of the specific topic or challenges that people face today. So the pricing. The relationship with Christian, myself, in the Moving Titles in Commerce workshop is not free. To join this private workshop study group and have access to me is option one, $299 for one workshop, and that's consisting of 20 hours total. That is 10 two-hour sessions in one workshop for $299. That's option one. This is all on the website. Option two is it's per person. We'll pay for two successive workshops, one right after the other, at the special price of $249 price per workshop. That's $498 total, and that's a savings of $100 for two successive workshops. So if you want to buy two workshops, two successive workshops, one right after the other, you go for option two and save yourself $100. Now, what is the workshop? Each workshop includes your World Wide Web access. That's a must. You must get on this workshop through a computer. You have a web-style desktop access by computer. It is a must. So you have this World Wide Web access, and it contains the phone number access to each workshop session for 2 hours per session. 2 sessions per week for 5 weeks, totaling 20 hours. The price includes access to all the past show recordings recorded for personal study. Registration is required payment method will be released along with a start date and a time in January, February here. And tentatively it's set for Monday and Thursdays at 10 to 12 p.m. Eastern Time. And make sure that you've ordered the Gilbert Law Summaries Trust by Edward C. Halbach Jr., copyrighted in 2008 by Thomson West, and it's approximately $28. And also get a Black's Law 8th edition, or say the 9th, and the UCC with the official comments. You need the official comments. Don't just go out there and buy a UCC without the official comments. You'll be hampered. And these books are in addition to the workshop price, and you must order them separately. And you also must request a registration application from me at NTT registration@movingtitles.com. Request an application, registration from me at NTT registration@movingtitles.com. In addition to the Moving Titles and Commerce Workshop, everyone has this show and the other shows that I have on Tuesdays and Wednesdays. And all this is spelled out on the website, so go check the website out. That's movingtitles.com. Punch that into your browser, and it'll take you directly to everything I just said right here. And again, my email address at that site is christian@movingtitles.com. And I thank you for your understanding, and I will be updating that continuously as we go along. So if anything new comes in, keep checking back with that website for some new information, or tune into the shows. I'm trying to get it updated as fast as I can. I plan on putting different contact information on there, putting some links on there, putting the schedule so that everybody could link into that and get all the downloads and things from the main site. So get accustomed to how to get into the main site, movingtitles.com. All right, so the big bingo's out of the Gilbert's Law Summary. Probably the biggest one in the whole book. Biggest one in the whole book is on, for those of you who have the book, it's on page 131, and it's under section 460. And section 460 is talking about spendthrift trusts. And when I read this, I figured, right off the bat, that connected for me, and I knew exactly what a spendthrift trust was. A spendthrift trust is the Declaration of Independence. And the Declaration of Independence is nothing more than a charter that was given to us by God that gave us unalienable rights, which this country was founded on in 1776. So, spendthrift trust in Gilbert's Law Summary says that a spendthrift trust is one in which, by statute, or more often by virtue of the terms of the trust, that's the Declaration of Independence, the beneficiary is unable voluntarily or involuntarily to transfer his interest in the trust. That's what unalienable means. Can't transfer it. So, in other words, he cannot sell or give away his right to future income or capital, and his creditors are unable to collect or attach such rights. His creditors are unable to collect or attach such rights. And this type of trust, in other words, Declaration of Independence, is usually created to provide an interest for the beneficiary that would be secure against his own improvidence. In other words, if he did something wrong, he would not lose any of his rights. Can't take them away. He's got them forever. And that protected him from him doing something wrong, and he would lose everything. So our founding fathers were tired of Britain's chains upon us, and they came up with a declaration, a trust, granted by God that all men were created equal with unalienable rights, basically, and that their creditors are unable to collect or attach such rights. That was in 1776. So now that was the estoppel, and that was by res judicata. Now I'm going to go forward a couple pages to page 139. 139, section 498, where the Civil War was fought over basically the war debt of 1776. The South, figured they didn't have the assets. The North was strong and industrious, and they had all the money. And the South didn't want to pay, nor they thought they couldn't pay. But anyway, somewhere around that time, say between then and 1933, there was a protective trust that was put on. Now, Section 498 in Gilbert's Law, page 139, says that a protective trust has long been used in England as increasingly used in American jurisdictions. A protective trust usually is an ordinary trust that pays out its income regularly, but which upon an attempted voluntary or involuntary alienation of the beneficiary's interest becomes a discretionary trust. So upon the time of the creditors trying to put a lien or trying to get at the beneficiary's assets, a discretionary trust was formed, protective trust. So all the assets in 33 that were voluntarily given into trust were given into a protective trust for a reason, because the alleged servants of the government said, hey, we want to protect the assets of the beneficiaries. In order to do that, we're going to put everything in a protective trust. They were following suit with the Declaration of Independence. But under the modern view, they're construing it that it could be taken now. So now I want to jump back one page, on page 138, and where it talks about discretionary trust on section 490, where it says a discretionary trust is one in which the trustee, and that would be, say, the U.S. bankruptcy trustee, is given discretion to make or apply or withhold distributions of income or principal, or both, to or for one or more beneficiaries. One or more beneficiary. And now you know why you don't get your remedy in a consistent measure. Because it's per the discretion of the trustee. Because he's still trying to protect the assets. Because the assets, if he transferred them to the beneficiary, would put the beneficiary's assets open for the creditors to seize. So that would defeat the purpose of the trust, 1776 trust, under a modern view. So now they put it under the discretion of the trustee to whether or not you get a remedy, or whether you get paid, or whether they withhold. And then some of you are taking the withholding and putting on a 1099 and taxing it back too, and then you find out the IRS seizes it, and you wonder why they seized it, or why they froze up the account. Well, they actually they withheld the funds and applied the funds to the debt, and you never knew it. It was under the discretion. And the Black's Law definition of insolvency is really boils down to, even though you have the assets, you stop paying your debts, you're insolvent. So even though we have the assets, we could pay. The fact that we've stopped paying makes us insolvent and bankrupt, and causes the trustee to be a discretionary trust and a protective trust to be put on, because people are sleeping because they think they don't have any money to pay the debt. And they're not telling you that you got a trust fund. Trust fund that you could pay the debt. So this spendthrift trust, this Declaration of Independence, which was when somebody voluntarily or involuntarily tried to transfer the interest, your unalienable rights, but the creditors are unable to collect or attach such under the older view. But on the modern view, they've changed this, because really nobody has expressed this trust being in existence, so that leaves them the ability to construe this trust with any way they want. And the fact that they didn't have the particular wording in the trust indenture, which is the Declaration of Independence, they're saying, okay, under this modern view, now whether or not the instrument provides standards for the trustee's guidance. That's under Section 490, discretionary trust. But his creditors are unable to collect or attach the rights, and this type of trust is usually created to provide an interest for the beneficiaries that will secure against their own mistakes. But anyway, let's play their game, because they're the ones that seem to hold the lock, but we have the key. Just like Dorothy had the shoes to get home, the power to get home, all along through the movie there, and The Wizard of Oz. So how are we going to take care of this? Well, we're always trying to do things backwards, and we need to reverse our thinking all the time, because most everything we know is black and really need to be operating by whites, and so we've been brainwashed into black. So you might as well just forget about everything that you know, because everything you know is really a lie. It's all in the public, and it doesn't work that way in our private world. We're always trying to take our private thinking and go into the public realm on their stage in their court and tell them all about how they should be running their foreign country, just like we went over there and told France, say, for example, how to run France, and what would France tell us to do? Go take a hike. In the meantime, they got you in that country, and they may lock you up because you're trying to force them into doing something they don't want to. So here you are in their courts trying to tell them what to do, dancing to their tune on their stage, and you're trying to give them all the laws in the private that they should be doing when you're sitting there in a public spouting off. You got to be an idiot. You got to be incompetent. And that's just how they treat you for a psych evaluation, because you're putting too much truth in their realm, and they don't want to hear it. And that's a warning shot against your bow on your vessel to back off. So, if you like swimming up a rapids without a paddle, go ahead. But now let's get smart. That famous show of the 60s. Let's take control by getting smart. So if we get smart by knowing and understanding, and we know how they're doing this under trust instead of debtor-creditor, instead of UCC, then we're going to walk in there under Sun Tzu, The Art of War, where I know my enemy, I know what makes it tick, and I know myself, and now I have both sides of the ledger under control. The fact that no party in the trust needs to know or understand they are forming a trust, now that's the grantor, the trustee, the beneficiary, does not negate the fact that a trust is legally formed. If all the necessary elements of the trust are there for its formation and a method of formation, then there is a trust, period. As long as you can prove trust, if you claim trust, and you understand and you know how this trust is put together, or any other trust, because there are many trusts being formed today, many sub-trusts, but only one main trust. That main trust, or that master trust, is the Declaration of Independence, and all other trusts are sub-trusts. And the main sub-trust is really the Social Security account, the SETI Key Trust. Now, the SETI Key Trust is a beneficiary trust, the Social Security account, that all other sub-trusts in the public realm are trying to gain access to so they can get the funds out of that through your dishonor. And they're trying to get through it by debtor-creditor under UCC. And when you fall into that trap, when everything is really operating by trust, you just fell into the trap. So you're trying to do a debtor-creditor relationship, and here's been a trust relationship. And the two law forms don't match. And I'll tell you, after studying all this for this time, I found out that the trust law, private trust law, is a higher trust law than even common law. If the power of trust is in equity. I've gone over the definition of constructive trust in Black's Law. If anybody has Black's Law, turn to trust. Trust, and then look up constructive trust. And it says under constructive trust, if we jump down into the little small print there on the 8th edition, it says a constructive trust is the formula, or in other words, the remedy, through which the conscience of equity finds expression. There's the power. There's the power of equity in a court. And today, equity has been redefined to be statutes and codes, but I'm talking about equity of pre-1933 especially, and maybe even back to, say, 1776 law form, because that's the law form I'll probably claim. Equity. What is equity? Equity is where court finds its expression. Its conscience is there. It's going to compel you to do what you didn't do, or it's going to compel you not to break what you shouldn't be breaking. That's the power of equity. And the power of equity is it's going to assume that the trustee is guilty once the beneficiary makes a claim and states a prima facie case. The burden of proof shifts to the trustee, and the trustee from that moment is presumed to be guilty. That's exactly how admiralty is working. But that's a direct flip-flop under trust. So actually how you think they've been getting them under the admiralty is really they've been operating as trust under construement because you never did express the trust and set up the parties correctly, and they're construing you to be the trustee, and you made out a 1040 form, which was really a declaration of trust, and you signed it and you set up your status as trustee. And now the fact that the U.S. Attorney's Manual under 6-4.010 says that all other agencies must comport to the IRS record, that individual master file in the IRS. All other agencies, Department of Justice, Department of Transportation, whoever, all those agencies have to have the same record as in the IRS. So if your IRS record is wrong, that you've been setting yourself up as trustee by your own voluntary actions, and you don't want to be trustee because you come walking into court and say you're a beneficiary, well, I'm afraid your court documents that you're putting in there are in conflict with what you said earlier, and you never corrected the individual master file. So if we correct the master file to the point that we're setting it up to something different, say like to comport to what you have down on Social Security as yourself being beneficiary, or maybe you want to change the beneficiary account to be trustee, but it all comes back down to knowing how to operate whichever position you want to fulfill. Because really the trustee is the one who's got the power to make the payment, but the beneficiary is the one who's going to receive it. So which end of the stick do you want to be on? You got the ability to set it all because you're the grantor. Your signature is required on every document that's in a fiction, because a fiction is dead and can't be empowered to do anything until it has a signature of a real live man or a woman. And you need to pay specific attention to what relationships you are forming at the moment you are signing something. Is that a trust you're forming? Because really it has to be, because there is no lawful money today. Can't complete a contract. No value for consideration can be exchanged because there is no lawful money. It's legal in their realm, But legal money doesn't pay anything. It just discharges it, puts it into the future, and it becomes debt upon debt. And if you people thinking you're getting into the DTC, I got some sad news for you people up there. You're going to get a dog bone of $35 billion, and you think you've got it all. $35 billion or more. And you're going to be so astounded by that figure that you're going to be blinded by the benefit trap you're going to fall into. Because they're going to give you those $35 billion plus in treasury certificates or maybe gold certificates, but they're all certificates, and ask yourself, what's a certificate? It's another fiction money source. It doesn't represent the real thing, only the title of a fiction. And it's on the debt side. It's all on the national debt side. And you're going to be compounding the debt. And here's the trap. If you take those certificates that you're going to get from them and you start spending it like money, you're going to fall into the trap, and you're going to be compounding debt upon debt again, which you were doing, but in a greater sense, you become a more highly paid slave. And they're going to love you for it because you're going to put more debt into circulation. But what you do from the point that you get those titles of debt is the most important decision you're going to make in your life. Because those debt titles under trust is what I want to use to merge with the asset side of the trust. And the debt side, when the minus side, liability side, touches the asset side of an equal amount, on the public side it's discharged, and on the private side it's set off, and the account is brought to a zero. And now you've paid your debt. But if you go out there and use those certificates that you get and use them as money, you're falling into the trap, and you're just a bigger debtor. So if we draw a 4-inch circle in the middle of a piece of paper, and we draw a vertical line down the center, and we separate the two circles, the circle into two, a left side and a right side. On the left side, we want to put in there is the minus side. That's the liabilities. And on the right side of that line is the asset side, the plus side. The plus side, that's the private side, on the right. On the left, the minus side, that's the public side. That's where all the debt is. So really what we got here is a ledger sheet. Now if we draw a horizontal line at the bottom of that circle all the way across, say, now you've got an upside down T account that everybody in accounting can really recognize. And that's nothing more than what it is, public and private. An account that both sides have to balance. So now on the left side, let's go to the right side. We're going to draw another smaller circle in that circle, and we're going to put in that circle, we're going to put a big capital T. And the T stands for titles. And then right to the right of that, we're going to put down below the foot of the T, we're going to put down an A. And the A stands for assets. So it's the title to the assets on the right side. So now we go to the left side. We're going to draw the same size circle, and we're going to put a capital T on there, which represents titles. And at the foot of that, we want to put a little D, and D stands for debt. So it's the debt titles, or the titles to the debt. At the top, outside the circle, you want to draw a small circle at the top and put SM in there because that's the straw man account. Now, under trust, we're going to draw a line from the titles to the debts, and we're going to draw a line, an arrow up to the straw man account. And under trust, we're going to move the title or merge the titles in that straw man account. And we're going to take on the right side the titles to the assets of an equal amount to equal the debt. And we're going to draw a line from that to the top of the straw man account. And we're going to move that title. And we're going to merge both asset titles and the debt titles into one entity, the straw man account. And under trust law, once an entity has both sides of the title, the trust terminates. We're going to terminate the trust on the straw man account by merging the two titles of the debt side and the asset side into one entity, thereby paying the previous war debt, all present debts, and if we don't incur any more future debts, we're fine. And now, with all the remaining assets in the trust ceases to exist, and the trustee must disperse the remaining assets in the fund, and you gain access to the whole ball of wax. Now, on the right side, you have we want to issue an order for settlement because the grantors, those people in trust, they always have to use non-precatory language. And precatory language means weak language. You don't ask, you command. You command, you direct, and you order. And we want to put an order in for a settlement. And on the right side, we put in order to do a set-off on the public side. On the left side, we put in an order to do a discharge. We put in an order to merge the titles. And we put in an order to convert and settle and close the account. Are you getting the picture? And once the trust terminates and there is no more trust, the line down the center gets erased. And America, the Republic, the common law, and everything that's been held in trust comes back. The two titles have been merged again, and now you have a perfect title. Because prior to 33, we had a perfect title. We had an allodial title. But trust came in, and trust splits title. Trust splits title in two. So we want to do the reverse of our thinking. So don't fall into the trap at the DTC that once you get in there thinking that you've got all the money, you don't have any of it. Because the bulk of it is on the other side, on the private side, that you can't see, and you don't know how much is in there. Because they've been holding all this in trust for you since 1776, and it's been multiplying up, and they've been taking good care of it until then, unless somebody's absconded with that gold. Another thing, if I put gold in trust, in kind, they're supposed to not commingle it. That means I'm supposed to get it back out, what I put in. If I put gold in, and they're going to give you gold certificates back out, they're in breach of trust because they commingled the funds, and that would be proof. So they're giving you a ball of wax of nothing. You got fiction money just like Federal Reserve notes, and if you go and spend that like Federal Reserve notes, you're back in the same problem again. Somebody wrote me an email, which was pretty good. He said here he had the sticking point that occurred to me as I was listening to your introductory remarks. He said that on one of the past shows he was listening to, I was talking about money where it was really worthless. It really has no value. In fact, you could probably go to the Treasury website, and I still have the documents where it says that the value of a Federal Reserve note is that it has no value, period, quote unquote. So he says if money is worthless, there can't be any consideration, ergo no contracts. Well, I agree with that because that's what I said. But wouldn't the same also apply to trust? So insofar as the res ties back to something that's dollar denominated, an example, I believe there was a discussion of legal action against a judge who refuses to cut a check to the would-be defendant, now a beneficiary, and that would be a check drawn against the res, which is worthless, so how could there be a resless trust in the first place? Good question. And then he wrote again another one. He said, hello again. He says, so by the way, he says, it seemed that some of your methods were predicated on the notion of the same person holding the offices of grantor and beneficiary. And then he puts in there, which I thought was impossible. And he asked the question, did I misunderstand? Well, under trust law, the grantor can be beneficiary, but he can't be grantor, beneficiary, and trustee. He can't be all three entities at the same time. That's the key. You can only be two entities. Grantor can be trustee, and grantor can be beneficiary. So really, he doesn't have an understanding enough about trust. So he goes on, could you break down for me what elements you prefer to move into each office, the grantor, trustee, res, and the beneficiary? Example, I would presume that a lawsuit itself is ideally converted into res. Yeah, that's right, it is. And by establishing two records that officials have granted it. Well, I don't think that the officials have granted anything because that would make them grantor. And I want to be the grantor. Whoever signs the document is the grantor. And he continues on and says, and that the would-be defendant becomes the beneficiary. Yes, the beneficiary can be the defendant, but you see, you didn't express the trust from the beginning, which you dropped the ball in setting up the positions of the trust to the parties. That would be grantor, trustee, and beneficiary. Now that leaves a door wide open for them to construe it any way they wish because you didn't express it. So you fell down on the ball the first time, and they picked it up, and they did it with a bias bent on their part, and they construed you to be the trustee. And in fact, there's confirmation of that because you've been filling out a 1040 form and declaring yourself under trust to be the trustee anyway. So really, you set the whole ball of wax up that way. And he continues on, he says, and the judge becomes the trustee then who charged with dispersing the case value. And they put in parentheses, as a security instrument. No, the case value is not a value, really. It's a res. And under trust, res does not have to have a value. Trust res is a thing. Under trust, doesn't have to be a value. Under debtor creditor, there has to be a value. There has to be a value under debtor credit because they want to tax it. A private trust is not taxable. And your res is not a security instrument. And anytime you have an instrument, you've got debtor creditor. And every time you have a security or a pledge, you have a trust. The security is a pledge. A pledge is a bond. And a bond is my word. And that's what a trust is, my word. It's not an instrument. It's a relationship. A relationship between parties in relation to a specific trust res, the thing, for the benefit of another party, the beneficiary. It's got nothing to do with value. It could be valueless, but it's still trust res. So it says, did I comprehend correctly? Well, kind of, but not all the way. So he says, I'm also curious about how this intersection with the jurisdiction over the defendant by construing the judge as trustee. Does he have to recuse for conflict of interest? Well, it's not construing because I'm really commanding, say, the judge to be the trustee. Now, he can disclaim and refuse whatever grounds, whether he says it's conflict of interest or not. That's fine with me. But a resulting trust is immediately formed by the court because a court of equity will not allow a trust to fail for a lack of trustee, period. So now the judge is between a rock and a hard spot, even worse, because now he's got to appoint a trustee. But then he goes on, does the next judge still treat you as defendant? Well, the defendant is the straw man, the account that they're trying to get into, but the defendant is not me. I'm the surety set up by the 1040 form and the declaration of trust with the IRS. And trustees are defendants in an action. So he says, unless there is a law whereby being a beneficiary of a case trumps one's status as defendant in a case. It's just confusing so far. Well, not really. It's really not confusing. You need to look under the Gilbert's Law summaries a little better and study trust. That's the whole problem. But these are good questions, and I'm sure they would probably, a lot of other people have the same questions. But the answer is in studying trust, which is many of us has not done because we're still stuck in debtor-creditor. And believe me, I've been there because that's where I came from. I mean, I was famous for doing except for value and having remedies for certain things that we've done, but yet that's what kind of got me into this because I don't care whether you use except for value, redemption method, litigation method, or whatever method you use from the A to Z gamut. Whatever it is, turned out to be nobody was really getting any kind of high success rate of anything. Everybody can claim no more than, I would say, success rate of, say, 8, maybe 10%. Well, that looked funny to me, and that's what made me start thinking another direction, really. Because none of us were getting a consistent, successful rate in any method that any of us were using. And when I came across that spend-through of trust, that was the bingo that hit me like a hammer dropped out of the sky. It just fell on me like a ton of bricks. That was the reason why you had less than 10%. It was a protective trust per the discretion of a discretionary trust, all for the purpose of protecting the assets per discretion of the trustee, and that's why you never got a remedy of consistent remedy. And really, they didn't care because you were thinking that you were getting a set-off, and you really weren't because you hadn't touched the assets on the private side. You thought you were getting a set-off, and here all along you've been doing a discharge under debtor-creditor relationship, and you never knew it. Everything we've done in the past, everything we put into the Secretary of Treasury, all those assets and things that we put in there, those birth certificates and things, all of those are done under debtor-creditor. They were not put under trust. They were not put on the private side. They were put on the debt side, the public debt side. We've done everything wrong. We've been led down the wrong path. And they're laughing all the way, saying, okay, that 10% that everybody falls into the trap doing that, that's designed to function as the currency under the debt system that the United States is stealing from us. For the voluntarily getting you to attach your signature to their instruments under debtor-creditor. So now we need to start waking up. We need to start searching out trusts. Start researching trusts. You're going to find a whole different picture under trust. Everything is flip-flopped, and we need to be going not down a debtor-creditor path because your remedy is not in debtor-creditor relationship as secured party credit. The remedy is in trust, and it's commerce through trust and equity. So we are really moving titles in trust. I was thinking about changing the title to the show because it's moving titles in commerce. No, it's really moving titles in trust. We're really moving titles in trust functioning as commerce. But you can't do commerce first as a debtor-creditor and think you're gaining standing as a secured party creditor. You must first come through trust position. But if you want to stay completely out of debt side, when I get done with this, I'm not doing any more debt, period. Won't have to. I'm going to pay my past war debt, pay all my past and present debts, and I'm not going to do any debts in the future, period. Now I'm not a debtor. I'm not operating in commerce. I'm staying solely in the private. Now I'm going to ask, well, how am I going to exist? Well, I got to work around for that, too, because it's the interest that is generated on the public side that its private source income is foreign source. It's held on the private, and therefore it's not taxable. And once I correct the individual master file, I do the W-8 bends, and I can do the IMYs without having any conflict of any other records saying that my instrument, my bends are no good because they don't match up with the IMF. When some intermediary asks me, well, what is your standing, your status? Well, I'm foreign source. I'm non-resident alien. Here, generate me some interest on the public side, which is not taxable. Here's my documentation to prove it. Deposit this in my checking account on the public side so I can write checks for services and goods consumed by the real man in the private.
Christian Walters.
Thanks, Desert. Did you give your address on if sent any donations, how to get the access through the website there?
Yeah, well, thank you, Christian. Of course, if you're tuned, most of our friends have access to the Internet today, so you go to therealpublicradio.net. You got up there the contact page right above the big word network, right above the K. You'll see contact, and then you go there. You'll see some pretty pictures as well of the stellar. In fact, we got the Daily Nebula now right near that urgent tab on the top left. You click on Daily Nebula. In fact, I didn't even do that today. I better do that right now. And you're going to see some profound phenomena in outer space. We had an eclipse there yesterday. We had a profound video there the day before. So that's a way to bring people into the network. We're trying to provide quality. But the contact page, you can email us at the contact page. If you send a PayPal donation, like if you go to the urgent tab and you want to get the lost writings, you want to get a sample of what we got so far, the dictionary, then you just on the PayPal. You put the message there that's what you want, okay? If you want to get this program with Christian Walters, tomorrow morning it'll be good to go. We can send it by Skype, by file transfer. And regarding the translations or this audio, if we can send you the translations by email or file transfer and the audio by file transfer, guess what? Any size donation, any size, because all they have to do is click a button. But we don't have any help. I'm a one-man operation here. And we can't burn CDs and do mailers and all that other stuff. It's just we're tapped out right now. But it doesn't cost us anything to click. So that's the way to do it. But remember, we do have to pay PayPal. Something for the service fee. Because some people once somebody sent $1. Okay, well we give our administrator that manages for us 25%. For doing it for us because we don't have a bank account right now, and then the PayPal gets about 50 cents at least on every transaction. So $1 or $5 hardly cuts it when you realize we're having to give part of that away. So I mean go figure. $10 minimum would really help to take us somewhere where we haven't been before. We could go on satellite. That's $1,000 a month. We want to expand our stream. That's another another $25 in the till. We just got enough to pay to rent this month. That's what we're dealing with, ladies and gentlemen. Do you hear what I'm saying? Okay, I don't have an automobile. I don't need an automobile. Don't want one. I can walk. Okay, but we do. We would, and I got a $20 watch. Okay, maybe it's less than that. We're not about money. We're about trying to serve and provide you with the most powerful information on earth. I've been doing this in this arena with the radio and the political arena and the law study stuff for 20 years. And I was a latecomer. You just came to the table. Well, don't feel like you're so green because I was late 20 years ago. We've got pioneers and forerunners that have been doing this a long time because people knew for a long time that something was wrong and they were trying to figure it out. So thank you. Be part of a revolution. Okay, you can feel good about sending your do-re-mi because it will help us to do better work. Look at our website, Sherry Sweeney of PatrickCrusade.org. We couldn't do that. She put out probably to date now about $13,000 in a year and a half to put all that stuff, all that content on our website. This lady's unreal. She's benevolent. She's fell from the sky. She's got vision. And we're all working together as a team, all of us. and you hear you're getting it, but you got to give something. And if you do that, we're going to do better work. Okay, bottom line. Contact page, all right? If you don't have it, then, my number, if you need the address for, rather than give it out and take any more time, give me a call. All right, my backup line is, during broadcasting is 304-629-7169. That's 304-629-7169. Numbers are on the website, on the archive page. We got our message up there. And any programming you heard, any program you heard on our network, you want it, you get it, just go to the archive page and there's how you do it, okay? Real simple. PayPal, send us a contact email confirming your PayPal, and say what you wanted, and we'll get it to you, okay? Backup line, our main line number during the day, when we're not broadcasting, is 912-882-2142. That's 912-882-2142. Back to Kristen. Thanks, Kristen.
All right, Desert, thank you. Take notice and acknowledgement with agreement that this show and our documents is private, not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions. And you will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic, informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or viewing this show or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Kristen, I just want to add, like we've got Matt in England right now standing by with a question on Skype, and if anybody wants to, tie in with our network on Skype so they can ask a question, or if they, want to set up for a file transfer, our Skype name over here for the network is Free America Radio. That's one word, Free America Radio. And then when you do the search on Skype.com, 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 free download, instant messenger. When you get on your instant messenger, you do a search for Free America Radio. It'll say Kingsland. You'll see it in Kingsland, Georgia. That's us. And then just ask us to accept your contact, and we'll put you in our phone book, and you'll be up to date on what we're doing here on the network, and we'll be glad to take your question that way if you want to do it, okay? Okay, Kristen, you good for a question?
Well, let me just go over the announcement of the Moving Titles and Commerce Workshop again. I have a new website for those of you just joined and didn't get the first part. You want to go to my new website. It's movingtitles.com. And you don't want to do a search for that. You want to punch that name into your browser. You want to type in movingtitles.com directly into your browser and enter, and it'll take you directly to the website. If you do a search or Google search for that, it won't come up because the site's too new. There's not enough information out there for a search engine to pick it up yet because there's no links and things. But if you want to access the information on the Moving Titles and Commerce Workshop, you're going to have to go to movingtitles.com, punch that into your browser, and all the information for the workshop is on the website. Its price, explanation of what the workshop is, what it consists of, all the times, what you get for the amount, plus my email addresses, and it's all the information is there. What you're looking for is right on that website. So check out the website. Again, that's movingtitles.com. Put that in your browser and go to the website. Okay, so why don't we open it up for some questions?
Okay, just hitting up our engineer over here. And, Matt, hey, Matt, good to have you listening in all the way over there across the big water. And we got more friends jumping on, and we got some Skypes coming through right now. Okay, hey, Desert, can I connect to NTT? Call. And, New Trust Technology, you bet. Come on in. Lost Lion. Okay, well, he's not lost anymore. And, okay, we got new people coming in from England. I can't get over it this week. Kristen, more people got into our Skype phone book, and so we've got you have a regular following over there in England, and it shows that it's a very common ground that we're all dealing with in this commercial world. Matt says, at present, what do you consider is the equivalent of the Declaration of Independence, i.e., the Master Trust, in the UK? Question mark. Though through my research, it looks like a likely suspect is, quote, the Treaty of 1213. I guess he's referring to the Magna Carta, the Great Charter. A quick introduction to this: in 1213, King John gave England to the Pope as a fiefdom. Okay, another contact coming in. Hold on here, Diane. Welcome, Diane. He gave the England to the Pope as a fiefdom. The barons and the English Church were outraged, and they came together. Welcome, Patrick, to our network. We got a lot of people Skyping in right now. I can't get over it. The barons of England church were outraged, and they came together under the leadership of Stephen Langton, Archbishop of Canterbury. They acknowledged the laws of Henry I, and in 1215 produced the Articles of the Barons, and eventually the Magna Carta.
Right. So I would ask, who was the grantor? Because that would be the starting point. If you say that was your 1213, say Treaty of Paris or the Magna Carta or whatever it is that you say is the document that gives you, say, the unalienable rights given to you by God, if the king granted it to the Pope, then the Pope is the trustee. Now, who's the beneficiaries? It'd be we the people again. If that's so, you're in the same situation with our Declaration of Independence, because the beneficiaries would be, say, we the people. But since you never claimed the trust, then how are you going to define who the parties are? And it's probably being construed for you, for their discretion, on their own bias bent again. All for the fact that you never expressed the trust. You never claimed trust and proved trust. So again, you're in the same situation as we are here in America as over there in the UK. So, really we have a parallel path, and our laws stem into the UK, really. Because we're studying a book, Practical Treatise on the Law of Trust by Lewin. It's an 1888 First American edition. But the First American edition, that book, is based on the 8th edition from England. So our roots stem from that. So I would say that, check in and ask yourself some questions. Who's the grantor? Who's the parties? Who's the beneficiary? Who's the trustee? And then if you don't like it the way it is, then look at a way of re-expressing it and correcting it, if that's the way you think it was made out. Think trust. Next question.
Okay, Christian. And by the way, that was not Magna Carta. I was wrong on that. It was predating Magna Carta. Let's see here. And by the way, you can raise your hand on the conference line, ladies and gentlemen, by hitting *5. That will raise your hand. And it looks like we got Rhonda in Missouri. Rhonda, you're up.
Hello.
Hi, Rhonda. How you doing, Trust Ambassador?
Good. How you doing?
All right.
Hit 6, Rhonda. Hit 6 a couple times. Let's get your audio up. Okay. Good shot.
It was interesting, Desert. He was just sitting there when Christian was taking a break, talking about how they was trying to hide nature from us. And not more than a couple hours ago, I was sitting here trying to look up nature in the Black's Law Dictionary. I got a 5th edition right now, and it's not there.
How about that? Well, I can tell you off the top of my head, out of Black's Law, the definition of natural. Natural means untouched by man.
It talks about the nature given by God in the Declaration of Independence.
Nature given by God.
Yeah, the nature of God. Nature.
Christian, could you go over that one more time when you was talking about when we issue an order for settlement, how on the right side we issue an order to
right? We're going to issue.
charge?
We're going to issue an order for closure and settlement. And that closure and settlement is going to consist of two things. It's going to be another order to settle the private side and another order to settle the public side. So we're going to issue another order to do the, what was the word I used? I forgot. We're going to command the discharge on the public side, because that's where discharge is. And then we're going to come over to the private side. We're going to command the set-off, because that's the set-off side is in the private side. So generally, we're going to give an order for closure and settlement, and we're going to give two separate orders: one to close and settle the private side, and close and settle the public side. We're going to do the discharge order. We're going to do the set-off order.
Okay, so the set-off orders for the private side and the discharge orders for the public side.
Correct.
Okay.
Then we're going to give an order to merge the titles. We're going to move the titles into that one-man entity. So each little thing that has to be accomplished, because if we want to close and terminate that account, terminate that trust, every little step along the way of the dominoes to get there all have to be in place by a particular wording to establish the connection and give them the commands or the orders to do what they're supposed to be doing.
Right.
And this is all under trust. All under trust, not under debtor creditor.
Yeah, it's amazing what those words mean. Just reading one of these pages of the 1888 treatise that we're reading, I got 3 pages of notes with definitions just on one page.
Yeah, you just got through one paragraph, right? Yeah. Yeah.
Yeah. So, okay, well, that's what I want to just kind of clarify in my own head there about the set-offs on the private and the discharges on the public.
Yeah, if everybody's paying attention, I just gave everybody the model how to do it.
Right. Okay, thank you, Christian.
Okay, I believe we've got here Michael and Abilene. Michael, you there? Hey, Michael.
Shalom, everybody. How you doing?
Good to have you.
Me?
New listener here, Christian.
Ooh. Can you hear me?
Yes, go ahead.
Can you hear us?
Hear me?
Okay.
Yeah, just want to say shalom. I've known about something for a while, Christian. I was waiting for you to bring up the right information, which you just did tonight, and also bring up that man that emailed you. I was listening to him the other night, and it was frustrating because he was still in a debt of creditor. But to really get back to what I was saying, a lot of people pertaining to Scripture, when it speaks of the word footstool, is speaking direct.
You just dropped off, Michael.
If you look up that word, you will find that speaking of the covenant and a trust, and of course.
Yeah, you've got a bad line. You're breaking up really bad. Are you on a cell phone?
He's on Skype.
Skype. Okay.
No, I'm on Skype.
Michael, try that again. Make that last point you were making. You got bumped when you were talking about, I think, the word.
Hey, back off your mic a little bit because maybe the compressor is squelching you out.
Okay, I backed off. Now, can you hear me?
Yes, try
Is that
again.
better?
Yeah, go ahead. Try again.
Hello.
Go ahead.
Well, the word footstool is the word footstool is in Scripture is talking directly of speaking of trust, the covenant, the original covenant, and also the Declaration of Independence, being that it's a sub-trust of the original covenant trust. And I just wanted to bring that to your point. Everything that you're saying is direct online, and really excited.
You just broke up there, Michael. Where'd you go?
He said he was really excited and we lost him.
Yeah, you may want to send it to any follow-up on Skype, Michael, and I'll be glad to speak for you on Skype. You came back in. I think I hear you. You there?
You there?
Okay. Yeah.
Yeah, I'm just excited. I'm just excited.
Very good. He's out there in the middle of nowhere.
Here's
Yeah, you're out in the middle of nowhere in Abilene, Texas, and I want to thank Michael. He did a wonderful gesture for us this week, Christian. He went to the university over there and got us a copy of the Syriac scriptures from the 1800s, the New Testament, so I could help perfect my Hebrew Gospel of Matthew translation I'm doing. And so he's a very great friend of all of us here, and helping us to make it a better world and be a part of history. So thank you so much, Michael. I do have the Syriac, but it's all buried in all my books, since I moved. So he helped me out and just got it. So we're going to make that available again to all of our listeners. The Syriac English New Testament, in particular, there'll be a parallel, three column parallel translation with the Hebrew Gospel of Matthew, the Syriac Gospel of Matthew from the 1800s by James Murdoch, and then also the Peshitta Targum, which is my original thought translation. So Michael's helping us out in that project. He was very giving, and thank you, Michael. And you better follow up, I think, Michael, on Skype if you have any additional point, or you want to try it real quick. Are you still with us? Okay. Then just do a follow up, Michael, by Skype.
Let me make clarification.
There you are.
Yeah. The master trust I'm talking about is Declaration of Independence, but yes, I recognize I've said on past shows that it would be the master trust really would be my Bible along with the Declaration of Independence. So really that's the master trust really. Just want to clarify that. So if we got another question?
Okay. Thank you, Michael, out there in Abilene. And let's see what we got down to the bottom. Nobody hitting *5. Nobody has a question for Christian Walters. Now, we usually have people standing in line at the end. We can't get everybody in. This is your moment. I know we had on tonight a lady called me from near Miami, and she wanted to possibly get some questions in. Maybe still not in with us yet tonight. *5 will raise your hand, ladies and gentlemen, or you can. We got some people that just had me accept their Skype. So if you have a Skype question, then bring it on, because Christian just loves to take your questions here. That's what we do a lot of towards the end of the programming. Oh, there we go. Okay, we got Andrew in Maryland. Andrew, welcome to the broadcast.
Yeah, this is Andrew from Maryland.
Speak, Andrew. Hit 6 about 4 times real quick, and you're low, and then you should be better.
Say 6 more times.
Yeah, just number 6.
You hear me now?
That's much better. Thank you.
Yeah, I want to ask Christian a question. I just got this book, Gilbert's Love Summary, and I got edition 13. They sent me edition 13. Is that the one you all are using, or is that the right one?
Yeah, I believe so. Just open it up on the 2 pages in and look on the left side. Does it say 2008?
I think it did. I'll make sure it's the right one that you all had, because they had 13th edition on the back, on the side of it, so I make sure I had the right one.
Yeah, that's what it says on mine, 13th edition.
Oh, okay, that's all I want to know. Okay, now go ahead and read. Okay, then.
The best I just got 2 fly pages in. The cover is one page. It says right there in a block, it says copyright 2008 by Thompson West.
Right, okay, I think that's what it is. Oh, okay, then thank you.
Yeah, you're on the right page.
Oh, okay, then.
What you want?
I just got it, and I made sure I had the right one.
Yeah, here's the key points of the book so far. If you send me a download request for the links, at the bottom of the download links, I have the key points listed. But just for record here, the key points is starting out on page 6. That's under section C, which is talking about relationships. And then on page 18, section A is the elements of the trust.
Okay.
Then page 28, section number 1, section 104, which is talking about segregation of res.
Okay.
Then on page 30, number 2, section 111, talks about special deposit.
Okay.
Then page 78, under A, talks of methods of trust creation.
All right.
Then page 127, under A, talks about alienability of beneficiaries' interest.
Mm-hmm. Okay.
Then page 131, number 2, under section 360, that's talking about the spendthrift trust, or the Declaration of Independence there. And then I want to go through, in the protective trust, I don't have that one written down, and the discretionary trust and following sections there. And then the last one is on page 219, under D, as in dog, trustees' liability and beneficiaries' remedy. Beneficiaries' remedy.
Okay.
So there's the key points.
Okay, yeah, because I just got it, and I just said, make sure I had the right one so I can start reading on it.
Yeah, so.
Mm-hmm. All right, then I appreciate it. Thanks a lot.
Thank you.
You bet, Andy. Thank you. And let's see, we got a follow-up from Michael. We'll do this follow-up here. Footstool means controlling the main, / Declaration of Independence, Hebrews 1:13, 13:10. And another follow-up, Hebrews 1:13, but G1161, whatever that means, G4314, which G5101 is abbreviating. I don't know what that stands for. So I'll bypass that right there. Hebrews 10:13, from henceforth I guess he's referring to the Greek. He's giving me the references. He's obviously well-studied, Christian, and goes a little further than most people. Had a good metaphor. He gave me a good meaning of the metaphor of mountain means a place of putting where you put your stash, so to speak. But it's really referring to the mind. So when the scripture says, we have to move mountains, it's the things within our mind. That's very indicative of what you're doing here on this programming. We got to move mountains. We got to move away all that refuse that they poured on top of us so that we could never see the light of day. And so anyway, thank you, Michael, for that. And mountain also means mind as well. So really enjoyed interacting with you this week. Now we got someone in the 201 area code. Please state your first name, where you calling from.
Yes, Bill from New Jersey.
Hi, Bill. Good to have you. Hit 6, Bill. Just boost yourself a little bit, but 3 times. Hit 6.
Is that better?
Yeah, you're good. Thank you.
You asked me to hit 3 6s. I don't know about that. That's like 3
well, you can do 4. You can do 1 more if you feel better about
it. Anyway, I'm just curious, Kristen, the name of that trust treatise, what is the name of that
another call was referring to?
Yes, you can do a Google book search for that on Google Book. It starts out, the title of it is A Practical Treatise on the Law of Trust, plural.
Okay.
A Practical Treatise on the Law of Trust. That's by,
that's one of the things.
It's the 8th edition by Frederick A. Lewin, Lewin. It's 1888 version. It's 2 volumes. The first volume pops right up pretty good, but then, I got to do some searching to get to volume 2.
Okay.
But if you put in volume, that's VOL and II, then it should pop up, volume 2.
Practical Treatise on the Law of Trust.
Yeah, just put that in quotes. A Practical Treatise on the Law of Trust. Put it in quotes.
Cool. And this is in preparation for the workshop?
No, that's what we're going over with the trust ambassadors, really. But if you want to study that on your own, or join the trust ambassadors, one of the two, we're going over that. And actually, this is how they're getting you. This is the model that they're doing. This is what they're using. This is the private trust.
Okay, what is a trust ambassador?
Well, a trust ambassador is a person that wants to study and form his own group and has people under him that he's going to pass the knowledge through, and the trust ambassador has access to me.
Okay.
So I'm going to pick 12 trust ambassadors, and I'm going to feed into those 12, and those 12 are going to get 12 under them, and then those, so we're going to do it.
And so how does one qualify for that?
Send me an email at movingtitles@hushmail.com.
Mm-hmm.
Or you can send me an email at movingtitles@hotmail.com. In fact, that might be the better one, early.
Okay, Hotmail?
Yeah.
Hotmail? Okay.
Send it to the Hotmail account and ask for, that you want to be a trust ambassador.
Okay.
Give me some
Thanks a lot.
But the requirement is that you got to have your 12 and you got to have a group, and then we're going to have meetings with each private group. And
okay. I need 12 people who want to be
under you
about trust.
Yeah.
Okay. Cool.
And really, everybody can have access to the Internet. They don't have to be local people. You can form a group of people that you meet out on the Internet, say, that are interested in this, get them under you, and you can have a group just like we do here on a conference call.
Okay. Well, something to shoot for. Let's do it.
Hey, thank you, Bill in New Jersey.
Okay, thanks, gentlemen. Appreciate it. Peace out.
Okay. Peace on. And we've got the Hanna family up north, and they just simply say, are these documents available for donation from anyone?
These documents pertaining to what?
Well, good question. I guess trust. Okay, he's adding here on Skype trust.
That's too vague. If they could Skype back with a little more specifics. Because we've talked about UCC, we've talked about, Gilbert's law summaries with practical trust, and
I have a package of law research documents I'm making available. It's not endorsed by Christian. It's just something that's somewhat related, but it's not a package by Christian. And if anybody wants to make us a donation to get that package, it's got trust information in there. It's got other different type of law-related information. Without going over it, I'm not going to do that. So you can ask that, and you'll have stuff to look at. It's just good to look at, as much as you can to get absorb the phenomena going on in our universe. So get a Black's Law dictionary. That'll get you busy for about 10 years. Okay, follow up. Okay, I came in late. You mentioned private trust formation. Okay, that's follow up. So you don't have in other words, you don't have any documents for people to download at this time.
Oh, I understand what they're talking about now. No, I'm not advocating private trust for asset protection. No, that's what everybody's doing, and they're selling packages for $3,000 or more. I know a woman who spent, for 2 trust packages to protect her assets, she spent $75,000.
Wow.
$5,000 for 2 trust packages for protection of our assets. We're not using trust for protection of the assets, although that's what it could be. But we're using trust to get a remedy. That's what NTT is all about. That's what all new trust technology is all about. Getting a remedy through trust, not about protecting one's assets. You're trying to protect your assets from the under debtor-creditor relationship, from the creditor from coming at your assets as you, the debtor. No, I'm trying to get you totally out of debt. Period. Misunderstanding. That's what the whole Moving Titles and Commerce Workshop is about. NTT is New Trust Technology, utilizing the Moving Titles and Commerce platform as a remedy That's a quantum leap in technology. There's nobody in the country talking about this stuff in the world, as far as I know. This is catching on like gangbusters. We're riding a wave, and everything is totally new. The way we're looking at something that's been in existence for hundreds of years, and how they've been getting us to pledge our assets and hypothecating us as to being sureties, and it's all under trust, not debtor-creditor.
Mm-hmm. I got a Skype from Patrick Devine, Christian. He says, I tried to send the 1099A group to you guys. Okay, whatever. So, I don't know where you're supposed to look for it, but he said he tried to send it.
Okay, I got an email from him. Thanks, Patrick.
Okay.
Appreciate what you're saying.
Very good. And, okay, we got a couple more hands here. We've got unknown. State your first name. Where are you calling from, please? Okay, well, let me try it again. Unknown. State your first name. Where are you calling from?
Christian, Eric, Florida. How you doing, Desert Al?
Hi, Eric. Good to have you.
Good, Eric. How are you?
Yeah, Eric, hit your 6 3 or 4 times, and that'll boost you up. Everybody seems to be low when they first come on, so just do that, everybody, if you can take note of that.
Okay. How do I sound?
A little better. I'll work on this end. Go ahead, Eric.
Okay. Couple of things. One is I was looking up the definition of the word defeasant in Black's Fourth, and the definition is an instrument which defeats the force or operation of some other deed or estate. What do they mean by other?
Read the definition again.
Hit your 6, and hit your 6 a few more times, Eric. I can't seem to boost you.
I'll do it again.
All right. 4 times, 5 times, 6 times.
How's that?
Well, hit it about 5 times.
How's that?
Okay, that's a little better. Go ahead.
All right. The definition of defeasance in Black's Fourth, again, is an instrument which defeats the force or operation of some other deed or estate. So that which is in the same deed is called a condition, and that which is in another deed is a defeasance. What do they mean by another deed? How many deeds do we have?
Well, you see, the king is trying to get in by escheat, and in means they choose an action in an action for a contract. And escheat means that he is trying to get it back by cheating. And if you look up the definition of in Black's law, you'll come up with that, and you look up the definition of escheat. So the king is trying to get in possession of the property because he's wrongful holder, really. And that's the others that they're talking about, because that was the reason why trust came about, because the Lord his property was vanishing because people were starting to put the property in trust, and they weren't fulfilling the obligation back to the Lord. So
is that something that applies in the modern day?
No, I think that's an older term, really. But really, it's coming back in with a bill in equity, which is nothing more than a counterclaim today, and summons in the fiction, because that's what happens. That's what they're doing to you. So your bill in equity is a counterclaim, and that's going to be what overcomes what they're talking about. And you're going to do this under equity to get your property back and restore the property back into the rightful owner, because that was the purpose of the trust to start out with, and the purpose of the subpoena, because the subpoena was originally the pledge. Surprising enough, the subpoena was originally the only pledge for the due execution of the trust, being the faith integrity of the trustee, and it was the device, it was the writ of subpoena by which the trustee was liable to be summoned into chancery and compelled to answer upon oath the allegations of the Sedicate trust, the beneficiary trust, the beneficiary bringing the allegations against him that, hey, you didn't pay me, you got my property, you withheld. So they used the subpoena after the summons for the corporation was the summons, and then if the surety didn't show up, who was the pledge, then you use the subpoena for the real man. And that's how we're going to subpoena people into chambers, with the subpoena, because the subpoena is for the real man, the surety. The summons is for the corporation. We're going to summon the corporation in first with the counterclaim, the bill in equity. Then we're going to do the setup of the trust into chambers with the evidence, the SOI, and we're going to summon into chambers the surety for that counterclaim. So the pledge really... Yeah, go ahead.
Okay. No, I didn't want to interrupt you. If you're going to keep going, keep going.
I was just going to say the pledge is the surety, security interest in property, which is the title, the property interest being created by bailment or other deposit, and there's your special deposit, for the purpose of securing the debt or the obligation. Because at first they were relying on faith and integrity, which was really confidence. which con means living, and fidens or fidea means faith, living by faith in the trustee because of the pledge that he was going to do a duty, and he decided to be self-centered and keep the property from himself because nothing was really in writing.
He who?
The trustee. The trustee was self-centered in keeping the property for himself because there was nothing in writing. So this writ of subpoena came up in 1360.
That about 20 times. Hello?
Yes, go ahead.
That was just basically the history of everything that's gone on. So I have to go back and listen to that word by word and pick that apart. But I was doing a lot of listening to some of the stuff you were talking about recently, and utilizing to get into court in the modern day into the equity side, utilizing the protective order to protect our CCI and so we can go ahead and bring our NOI in, and getting all the elements of the protective order in that. Now, beyond what's in O'Connor's 2010 civil rules, is there anything that you would suggest that we put in that protective order beyond how that describes the elements, and anything else we can utilize to make sure that we have good force and effect with it?
Well, yeah, it tells you how to explain why you need the protective orders under that O'Connor's, but then you're going to have to make sure to prove the trust that you've got the records of the elements and the method of formation so you can prove the trust, which would be our CCI information. You have to get some kind of notice probably there on the public side to give notice that you're holding the private evidence, and it's going to be put into chambers. But that's why you want the protective order, because it's trade secret information, it's state secret.
Oh, and by the way, I was doing some more listening, and you talked about state secret and how that's I think in Black's 8th, and it's not in my 4th, so now I know why I need an 8th, because there's just terms in there that you're going to refer to.
Yeah, I have a 4th revised, a 7th and 8th, and a 1st and a 2nd and a 5th, so, yeah. A good place to really all over heard some older law dictionaries is go to some bookstores. Go to some used bookstores and look around. You'll probably pick some up, some old volumes of Black's, for like $5-10 probably.
Now, when we go, once we get into the equity in the chambers and in camera on the equity side, and get away from that law on the colorable side, when we go to prove trust at that opportunity, what is going to be our best way of proving it? Is it in terms of the different methods of formation? In your opinion, is it going to be through declaration or by transfer, or can we have it? Can we prove trust through multiple methods of formation, or is there only one and exclusively one when a trust gets formed?
Well, it's under your discretion. So just as long as you can prove a present transfer, which would be a manifestation of your intent and purpose that a trust was formed. It's a present transfer, and you got to prove a present transfer or a past transfer.
So give us a scenario what that transfer might be in this type of context, for example, with a mortgage note.
On a mortgage note?
Yeah.
Okay, well, let's see. I would do one of the 4 methods of transfer methods of formation I would use would be transfer, number 2. And under transfer, there's 4 subparts, and it's A is endorsement, B is delivery, and C is assignment, and that assignment's on UCC 3, and D is by operation of law. So I'm going to do a notary presentment of documentation of my records. Once I do a UCC 1 claiming and a transfer on a 3, and I have the county two county records to prove the 1 and the 3, then my notary certificate is going to be the public record along with my other records that I pulled out certified of the 1 in the county and the 3 in the county. Those are going to be my records that I did an assignment, a transfer, even though it might have been 5 years prior. So I put in there that it's going to be nunc pro tunc because they've been holding the documents for, say, 5 years. It happened 5 years ago, the closing, say. But I just got around to now doing a present assignment, but really the present assignment was really, that's the confirmation of, or the manifestation of what happened 5 years ago. And transfer, whether it be any one of those 4, which if I had a green card attached to the presentment of the notary, it would be a delivery of the green card notification, and there also would be an endorsement on that. So I got an A under endorsement, I got a B under delivery, and I got a C in assignment of the UCC3, all representing a transfer by the notary, and the UCC 1s and the 3s. And that's how I'd prove it. And it's nunc pro tunc now because when the transfer actually took place, when I actually handed them, say, the note.
Now, because we're going to utilize the UCC 1 and 3 to prove trust here, Now, is that going to be considered CCI?
Yes. It's all CCI. Trade secret.
That is not. So that is not something we would file into the public record. That is something where, for example, we would file the notice of the registered mail number that we talked about in previous calls, and then hold on to that in a private capacity.
Right. The UCC 1s and 3s is nothing but a notice anyway. The information, that's just nothing but a notice filing. And then I'm going to do duplicates of that in the county.
But even if we do the duplicates, is that something we want to file into the public record or only refer to it through that registered mail number you talked about previously?
What is recorded in the public register, I can put in on the public side because that recorder is public to begin with. Those are just notices. But the actual wording and the consistency of the details of the documentation and the originals are with me, held in private. There seems to be a very, very shaky understanding of this public-private setup here about how to keep information, because we have a tendency to throw everything we got into the public side of the court, and we think we're doing it right, and we're doing it all wrong. We're waiving it all. We should only be putting notices in there, so people have a bad understanding of what a notice is. A notice is just a simplification of, say, identifying the specific res by, say, a number. And all I really have to do is just put that number reference into a notice form and put that notice into the county and then pull out a certified copy. And that notice, is let me see if I can pull one up here quick, just for an example.
And while you're pulling that up, you're referring to that registered mail number, for example.
Yes, right. That's the whole thing.
Yeah, because if we go ahead and disclose too much on the outlaw side of the court, we're going to turn our 900-pound gorilla into a 90-pound weakling.
Right. You're going to waive all your CCI information and then no SOI to support your NOI, and the judge is going to say, I don't see a trust here.
Because, of course, that's too much truth for the court, and they can't disclose that state secret information in the public.
Now, this is verbiage only for the notice on the UCC-1 claiming. I would reword this a little more for the UCC-3, which is the assignment or the transfer.
But now, which block are we talking about here?
This one's a notice. This is an example. So it says, this is actual and constructive public notice by grantor as owner and holder of all right, title, and interest with the non-negotiable instrument claim number RA123456789-UF with all attachments and proceeds therefrom as being held in the private. That's all you need. If there's any information regarding this that needs to be gleaned, please contact the grantor at the address below. And then just put a jurat on that. So there was nothing specifically giving any kind of details to anything held in the private other than a reference of the RA number that we're using, a registered mail number. Even if it was a case, I wouldn't put the case number in this notice. I'd reference the case by an RA number. And the only thing that shows up in this notice is any kind of identification is that specific RA number, which references back to all the documentation that I'm holding in the private with all the details and the facts and the figures and who's in it. And it's private. If I'd have recorded that with this notice, I just waived it and gave it back to them. So now I put this notice in there with just these 3 lines in here, pull that out certified, and that's what I attached to my UCC-1 certified copy, and I attached that all to my documentation held in the private. And I would word this a little bit different to make it reflect that this is being transferred for the UCC-3.
Now, would you share with us a wording type of model for an NOI as well, or is that the wording model for an NOI?
Well, the NOI is, say, like a public motion that I put in there that there's a trust here.
And is that just another simple 3-line type of document?
Yeah, that's basically what we used in our documents that we had in the case that stopped a foreclosure on the sale block. All we did was we just expressed that there was a trust, and we were the beneficiary, which was a conflict of the construment, and then construing us to be the trustee. And we pointed out that they couldn't have given free and clear, passed on it to a bona fide purchaser because they had had notice. That stopped the sale. No, that might not stop.
And and the NOI is something that we can file into the public as far as a motion on the outlaw colorable side. No problem. That's totally acceptable.
Say that again.
The NOI is totally acceptable to file on the at-law colorable side.
Yes.
Without a problem. We're going to file that as a motion in the public side.
Yes, the fact that I'm expressing there is a trust here.
Okay. Do we even want to put that there is a trust and disclose that there's a trust on the public side, or do we just want to say something, use some different wording, or do we actually want to use the word trust?
Well, see, my bill in equity would be my counterclaim, which is going to be in the modern time, the counterclaim is going to be the NOI. And that might be, say, breach of trust, cause of action, or breach of fiduciary duty. But if I'm claiming a breach of trust or a breach of fiduciary duty, then I'm going to have to be able to prove a trust. Although I've got the cause of action in there, which is my bill in equity, and I went over that on one of the other shows, bill in equity, it's right out of Black's Law. It lists the 9 things that a bill in equity has to have with it. And also the bill in equity is in the Gilbert's Law. Again, let's see if I can find it quick.
And while you're looking for that, do you know what show it was that you went over bill in equity, so I can go back and
gosh,
that link?
I've done so many shows, but it's been recently.
Okay. Here this month, you think?
Oh, yeah, within the last week, probably.
Okay.
It was either on the Tuesday or Wednesday show. All right, bill in equity is on page 130, section 456, where bill in equity, it says, or its equivalent, alleging no adequate remedy at law, that is, that the judgment creditor had sued out a writ of execution which was returned unsatisfied. The equity court could then decree that the trust income otherwise payable to the beneficiary to be paid to the judgment creditor to the extent required to satisfy the judgment. But then look up bill in Black's Law 8, and it gives you the counterclaim. And bill and Black's.
And while you're getting to that, and the reason there's no remedy at law is because the bank is insolvent, and as a trustee, you can't pay an insolvent party.
Yeah, there's no money. You won't get a remedy.
Right. But that's why there's no remedy, right?
Yeah, right. There's no lawful money. You can't get a remedy in a court today. So bill in a Black's Law 8, it says a formal written complaint, such as a court paper requesting some specific action for reasons alleged. And number 2, an equitable pleading by which the claimant brings a claim in court of equity. There you go. Before the merger of law and equity, the bill in equity was analogous to the declaration in law. And there's 9 parts to every bill in equity, and they are 1, and it goes through all 9 of them. I like the last one, the 8, it says, or 9, the process to compel. And number 7 is the interrogatories.
Now, in some of your recent calls, you were talking about that we are in a mortgage situation, and when we go to put that NOI in, it may work very well to express both the statutory and on the colorable at-law side of the court and a private trust on the equity side.
Yeah, in order to statutory trust on the statutory side, which would be the public side, and I wouldn't have to have any worry about bringing in evidence because it's all public anyway. But then I could run a dual trust case on the private side.
And the reason that we would want to run a statutory trust case on the colorable side is so we can go ahead and utilize our causes of action that you had talked about in the past, right?
Yeah, you could get a judgment just on the public side just from that.
And when we're expressing that statutory trust, obviously there's going to be one of the methods of formation. But what would be what would that model be? Give me an idea what that model might be. That statutory trust.
The model of the statutory trust.
Yeah.
It really is all of Gilbert's what we've been talking about. Everything we've been talking about in Gilbert's is really statutory trust. The 4 elements, one of the methods, formation, same thing.
And in order to bring that in, because it's on the colorable side, would we need to do an NOI, or could we just go in with an SOI on the colorable side?
Well, if you come in on the public side with a strict litigation and you want to bring your facts in on this pertaining to a statutory trust, you're going to make it all public. But yeah, you might be able to do it that way and win that way. But I don't want to release my 900-pound gorilla to utilize a 90-pound weakling. Yeah,
but I do.
There's no equity courts today on the public side. You got to go in chambers.
Right, I realize that. But in order to utilize the causes of action that we had talked about, unfair business practices, I know antitrust. There was a few others. But in order to do that on the public side, as you had expressed. What I'm wondering is like, what would be some of the documents? Like, what would be the first document we would want to file in order to express that? Would that be a motion? Would that be
the account and the bill of equity with the cause of action? That's going to say, hey, I got a trust here. It was a breach of trust.
And is that on the colorable side, on the statutory side?
Yeah, that's on the public side. Yeah, the colorable side.
Okay, so that's the counterclaim we're going to bring. Okay, because, for example, they're going to go ahead and they're going to initiate their suit with the foreclosure, for example, here in Florida, and then we're going to come in. Our answer to that's going to be the counterclaim on the colorable side, expressing a statutory trust, and then also putting in an NOI so we can go ahead and utilize both sides and control. Actually, could we control that statutory trust from the private side? Could we control that action from the private side?
Yes, that's where the control comes from.
Ooh, nice. All right,
because one of the equity, once the trust has been proven, now you got existence of a trust, and if you construe the trustee to be them, once the beneficiary, which would be you, makes the claim that there was a trust, proves the trust, and then he puts in a claim that there was a breach, that they didn't make the payment of the disbursement, the court of equity is going to automatically presume that the trustee is guilty. The burden of proof, the onus probandi shifts now to the trustee, and he's presumed to be guilty. And the only way he can prove his innocence is if he has a record of a payment or a record of a disbursement. And the only thing the court wants to know is, did you make a payment? And when are you going to make a payment? That's exactly what they get you under an admiralty. And here wasn't admiralty at all. It was trust.
Now, when we're talking about the designation of the trustee, are we talking about the bank, for example, in this context?
You got the ability as grantor, because you were the signer on the note and a mortgage, to assign any parties that you want. But in this case, you already assigned the bank being the beneficiary. Title company was the trustee per your power of appointment that you gave on the application. So now you need to do some switching the parties around, get them around in the right spot. So you're not going to have a chance to change the beneficiary because that's the bank. But, I can merge the titles in the bank. If I come in and say there was a special deposit being in the note, which you never expressed from the beginning, now if I come back in and non-pro-tunc back, it's been a deposit, what you do with my funds? Oh, you don't have it? You securitized it? You commingled it? In other words, oh, well, that's breach of trust.
Nice. So again, as you said, the title company is the trustee at the closing. Now, am I going to utilize them as the trustee in chambers?
No, they don't serve a purpose of being trustee any longer. The deal's all closed. But the bank is still...
So who am I?
No, I'm going to appoint somebody else a trustee.
Like who?
The bank.
But they're the beneficiary.
Great. What happens when both titles are in one entity?
Terminate.
Terminates.
Thank you. That just and as the settlor or grantor, whatever term we want to use, now we merge. And I remember that. Okay. Now this is really the fog is starting to clear now. And
so now I do a conversion, an order for conversion. Convert the funds held in special deposit to cash, and then do the set-off and the discharge. You don't have the funds? What'd you do with it? You securitized it? Oh, I'm sorry, you commingled the funds. You're in breach. Breach of trust. There's my cause of action. There's my bill in equity.
And then we go back to the colorable public side in order to collect damages for that.
Yeah, now the bank is trustee and beneficiary. Now, who's guilty on a switch of the onus probandi? And who's deemed to be guilty can't prove themselves innocent unless they got a record of a payment. You got them in between a rock and a hard spot.
Now, would you repeat that Latin term?
Onus probandi, the burden of proof.
Is that O-N-U-S?
O-N-I-S.
Okay. And I've heard plenty of people talk about the title page and the title page saying that it was that the loan was paid off. Who actually holds that? Does the title company? Does the bank? Or who actually has possession of that document and the allonge?
Who has possession of what again? The note?
No, the title page and the allonge.
Oh, I don't know. You might have to do some discovery, find out who's supposed to have it.
If anybody else comes on the call, if anybody knows who might have possession of that, in their case anyways, that would be great if somebody else could comment on that.
Once I issue, if I'm going to do like a 9-210A6 for debt validation, I'm going to specify the debt is zero. Give them 14 days to come back with that. Run a process on that through the notary. When they don't come back within the 14 days, have the notary certify that. That's good dishonor. Then is going to give me the doctrine of unclean hands like applying in this court also. But I really want to maybe not want to use that just yet. But that doctrine of the dishonor is going to give me the right to do the revocation of the signatures. Now I got a legal standing to make revocation. So now I can take and revoke my powers of attorney, and I can reappoint parties then.
Christian.
Yeah, Harold, go ahead.
Okay, with regards to the title page to the note and the allonge, that is all supposed to be together with the so-called holder in due course, the original docs.
Okay, that brings back case 82 that went over before under the except for value stuff I talked about, months back, where it was important, I think it was an 82 case or 85 case, where the Oklahoma case said it was important for the case to be first established who the holder in due course was, because the holder in due course was the one who had cutoff rights. Now, the bank is going to assume that they have holder in due course rights, but they don't. You do. Once you bring in the fact that you're the holder in due course and not them, because they're trying to cut you off. And if you're holding due course, they can't cut you off. And you got them that way. But that was the principle behind that Oklahoma case, that they wanted to know the Supreme Court had to establish who the holder in due course was first.
But that would be something, the holder in due course would be something we would want to express on the private side, correct?
Well, that might be, yeah, I think you're right. Yeah, that would be on the private side, yeah, because that would be, it's really through trust. It's not under holder in due course UCC Article 3 anyway. It's under trust.
Christian, just want to jump in and mention to our listeners in a little bit we'll be going to the Forbidden History series, Starfire Chronicles, with yours truly, Desert Owl, and special host Sol Junzul, and we'll be talking about the metaphors of life, about the enigmas within nature, and how to read it all, okay? And including the symbolism and the words, the word etymologies, and the occult nature of words. So that's coming up next, so feel free to stay on with us after Christian Walters. Love to have you. And please tell your friends, okay? You wanted to know, did you? Of course you did. Christian?
Okay, well, here's the bingo for the, if the beneficiary makes the prima facie case, and that's easy to do, the burden of contradicting or showing a defense will then shift to the trustee. Now that's Bogart's section 871 at 156-57. And you also want to see Scott's on trust at section 172 at 452-53, and Bogart also 861 at section 2-3. But then the burden of proof issue is one of the most significant distinctions and characteristics about trust law. Let me repeat that again. The burden of proof issue is one of the most significant distinctions and characteristics about trust law. The party claiming trust must satisfy the threshold burden, and there is no obvious transition from the threshold burden phase to the substantive burden phase. So where the claiming party claims trust is the beneficiary, what happens is that what is referred to as the shift in the burden of proof. Thus, there is a beneficiary who is asserting a trust, and the beneficiary is expected to be the party who files the suit or the claim, because the threshold burden of proof is on the beneficiary. Then, once the beneficiary satisfies that threshold burden, the burden of proof shifts to the alleged fiduciary or the trustee. And what does the trustee then have the burden to prove? The trustee then has the burden to prove compliance or non-breach. And if he doesn't have any evidence to that fact, then he's guilty. The point to make here is about the evidence is that the burden of proof is that once the threshold burden is satisfied, the law of trust presumes that the trustee is wrong or is guilty or has breached the agreement, as it were, and the fiduciary must prove, which he can't unless he's got a record, he must prove that what he did was consistent with the applicable trust agreement, grantor's intent, purpose, and with the applicable trust law. So thus, in civil or commercial context, the trustee is quite literally presumed to be guilty, presumed to have breached, as it were, and he must prove that he was within the terms of the trust and within the applicable trust law. That is, not guilty. Bingo! This guy's dead, unless he's got the money to pay. That's exactly how they get you. Now you know and understand, and you're a 900-pound gorilla in equity.
Just so you know, Christian, I'd like to get Matt from England when you're ready. He's got one follow-up standing by for a while.
Yeah, it's just the indisputable fact that such burden does not even exist until after the fiduciary carries the threshold burden to show, one, that the claimant is the beneficiary and of the trust, and with the trust res and managed by the alleged fiduciary. Got to prove that trust first. Now you got standing to bring the claim in. I didn't get paid as beneficiaries. Where's my funds, Mr. Trustee? Court of Equity assumes you're guilty. When you going to pay me? So
that's no different whether you go into chambers and fail to express in open court on a civil case or even on a criminal, because it's all trust. And when you walk in and say not guilty, you're automatically guilty, even though you stated in open court, because you don't have the money to pay, and that's why you got to go through the whole process. Correct?
Right, but I'm not going to say that in court. Yeah, I'm going to say that for
right.
Private side.
Right. So at that point, for anybody, it really doesn't matter what the violation of, for example, the Florida statute is in the criminal code. No matter what it is, if you go in there with an NOI,
I'm on private side trust. I'm not under statutes and codes in the state of whatever or in the United States. I'm not under their laws. I'm operating strictly in trust.
So when you walk into court with that NOI, no matter what the violation is, whether you kill somebody or whether you call jaywalking, it doesn't matter. As long as you go in with an NOI to get into the equity side of the court, then you can express and then assign the trustee. And in that situation, for example, in a criminal case, who would you want to assign as trustee? For example, the prosecutor?
I haven't been working too much thinking on say, a criminal case. I would still think the trustee should be the judge.
But they have a right to disclaim.
Yes, true. But that's great. That puts them in between a rock and a hard spot, because immediately a resulting trust is formed. Now they must appoint a successor trustee. If they don't, there'll be a violation of the bench under equity. That's worse than disclaiming. That's worse.
They have a fiduciary responsibility. Is that why?
Say again?
They have a fiduciary obligation?
They do, but they also have a right to disclaim, because if they disclaim, they can disclaim for any reason. But now a resulting trust is formed where the judge must appoint a successor trustee. And equity says that they must, because equity will not allow a trust to fail for a lack of trustee. Now they're in a deeper hole.
Because that train will roll on.
Yes. So they'd better appoint a fiduciary. Fine. Now let me know who that successor trustee is so that I can give them trust res and we can get this trust taken care of. Otherwise, you will be in breach of trust, and you will also be violating the bench, equity. You didn't appoint a trustee. And I hereby order you to appoint a trustee within 14 days and give me the address, the name of that trustee, so I can give them trust res, or else we got a complaint here.
And in that context, the trust res would be the case.
It'd be another case. I'm going to glue him into this. This is a big tar baby. You're going to be glued into this, Judge.
But, for example, in that context, that would be the case because the case is a presentment that has a value to it, right?
Yeah, but it's not so much a value. It's really trust res.
Okay.
Trust res does not have a value on it. That was one of that fellow's gripes about, because there was no money and how could there be trust res. There can be trust res without value because it's a thing. A thing doesn't have to have any value. Only under debt or creditor does something have to have value so they can apply a tax to it.
Right, and under trust, because it's all trust because of what happened June 5th, 1933.
Yeah, trust is a relationship. Trust is not a value.
Boy, that clears up a lot right there, just to have that understanding that whether it's civil or criminal, that trust has.
Yes, that's trying to make up the thing on the other show there was going over about interest. What is my interest in this case, $50? Or the fact that I loaned you money?
The fact that you loaned you money.
Well, it's relevant to whatever point of view you're coming from, trust or debt or creditor.
In trust, it's the fact that you loan money is a relationship here.
Yeah, it's this wordsmithing of words and the change in the meanings where interest is really talking about the res, the property that doesn't have to have any value.
And one of the things that would be great is if you wanted to put together a little test for us newbies when it comes to this, so we could know what we specifically need to be proficient in terms of maybe a quiz or a test. So when we are talking about this stuff, we have a good working knowledge of the basic terms, because I've heard you say on many occasions that we're all deficient in just the most basics, and that's where we're gonna hit the wall, I guess.
Yeah.
And hey, we'd sure love to have it.
Well, has anybody read from cover to cover Gilbert's Law Summaries yet?
And on your show, Matt says, on your show the other night, I heard that the process of getting private documents, evidence, into the private side of the court was causing one or two callers a problem due to them not getting protective orders put on their documents and the evidence.
Yes, correct.
Am I right in thinking that a way to go about this would be to put all your correspondence, documents, and evidence into a private trust, and therefore, I just lost him here. Hold on. And therefore, it jumped on me. Of course, document evidence in a private trust, and therefore, if this evidence ever needed to be brought into a hearing for any reason as evidence, then by the very nature of private trust, the judge would have no option but to arrange a private in-chambers hearing to have the evidence heard?
No, the protective motion establishes CCI information. And you have to prove in that protective motion that you have CCI information, like according to O'Connor's here in federal. And then once you have the establishment of the elements necessary for the protective order, they must grant the protective order. If they don't, they're denying you due process because they're not allowing you to bring your evidence in. So on appeal, that would be an automatic win.
Okay, Matt says you're on fire tonight, Christian. You're on fire every night, aren't you?
You know, I guess. I appreciate the kudos. Thank you.
Well, I'm just overwhelmed to, an honor to know you and to be sitting in this seat here and realize, we're, you're really making a part of history here. You're unraveling at the very, the center hub, the onion, where, in the it's kind of makes you want to cry all the way through the onion, but once you get to the center, it's really sweet, right?
Yeah, what I'm revealing is how to bring the Republic America back by terminating the trust. So that what was held in trust, America, the Republic, comes back. And if you understand what I'm talking about, you come to that realization. That's much more bigger than everybody's individual mortgage foreclosure, what little problem you got today. We're talking about the whole country. That's much more important than anything else.
Yeah. Okay. We got Rhonda. Hold on, Rhonda.
Tuesday's call. Let me give the number for Tuesday's call. Tuesday's call. That's the next show coming up. That's at 10 p.m. Eastern Time. The dial-in number for that show on Tuesday is 712-432-0075, and the access code number is 917030#. Again, that number is 712-432-0075, and the access PIN number is 917030#. Okay, another question.
Christian, it's Rhonda.
Hi, Rhonda.
Speak up, Rhonda. So hit your sixes.
Is that better?
Yes, ma'am. Thank you.
I was just sitting there listening to you talk about the judge or a trustee has the opportunity to not take to deny the trustee that position.
Disclaim.
But I was trying to find it in here in Gilbert's Law Summary. I can't find it right this second. But wasn't we talking the other night about that? We was talking about that, and it says they have the right to deny, but it says that if a trustee accepts any part of the trust, in other words, they can't pick and choose and say, okay, I'll take this part of the trust, but I don't want to take this part of the trust.
Correct. It's all or nothing.
Is that correct?
Yes, it's all or nothing.
It's all or nothing.
Yes.
So,
and once he's accepted, the trust becomes irrevocable for the trustee. That's what it's talking about, an irrevocable trust. An irrevocable trust is that the trustee cannot revoke the trusteeship once he's accepted. That's the true meaning of a irrevocable trust, not how they're construing it today.
Right, and what they're trying to do is not accept it or say that they don't have to accept it. But is it not so that if they accepted the case, which is a trust, are they not accepting part of the trust?
Yes,
and therefore
rest. Yeah,
don't have the ability to pick and choose what part of the trust they want to take or not.
Correct. Once they've accepted the trust, yeah.
So just by them accepting the case, the claim, the trust into the public side of the court, could that be construed by us that they've accepted part of that trust?
Well,
so therefore they
I would want to have material facts or SOIs to substantiate my claim that he has accepted trust res. And if he's accepted trust res, then he's got the duty.
He's got it all or nothing.
Yeah.
Okay, thanks.
But the section you were talking about is it's on page 35. It's talking about the effect of failure of named trustees or failure of named trustees. There's 5. And also, let's see, a little bit before that, so it was talking about the trustee and for his ability to disclaim. But it's under that section 2, under page 33 also. Starts at section 125.
Yeah, I just thought I remembered reading in there where they can deny being the trustee or waive being the trustee. However, but if they take part of the trust or accept part of the trust res, they got to take it all.
They've got it all, yes.
I mean, they can't deny then.
Right, right.
Okay, thank you.
Another question, Desert?
Okay, let's see here. Got Skyping with Lost Lion Mark up there in New England. Great to see all these wonderful people on our network. And hit star 5 if you have a question. We got a little borrowed time right now. We're waiting for Soljan to get ramped back up over there in San Antonio with his radio network. We're simulcasting 2 networks on the Forbidden History series. Star 5 raises your hand and want to welcome all of our new listeners. You're here every Saturday with all of our other friends on Money, Banking, and Trust by Moving Titles and Commerce with Kristen Walters, 7 p.m. Eastern Time, every Saturday, okay? And we're trying to make it a better world, but we can't do it without you. Where we can bring in a message, but you've got to, tell your friends. I got a real disturbing Skype earlier this evening, and and I talked, just like our network, like we get near 100 people on here every week, and then only 1 or 2 or 3 people, like every other week, will send a $5 or $10 bill, and and where's the other 60 people? The Skype I got tonight is that Christian's been doing this thing for a number of years now, and he may have gotten one $100 donation down the road, but he really does this thing without any remuneration as well. It seems like we're giving it all we got, and the Indians, for lack of a better word, forgive me, all of our traditional people, but we're all the Indians, because we're all struggling in our own way, in different ways, and but the collective people won't send anything because they say, well, I don't have a $20 bill, or I don't have 30 or 40, but you probably have $1, or you have a 5, or Christian doesn't ask, but it would be like a vote, it'd be like a heads up of support saying, hey, just go have lunch on me, and so please consider it, because you're all here every week and we're here every week. But you know what? Tomorrow we may not be here, because if we didn't have one, I would be having to move, the end of this month, if it weren't for one lady somewhere in Wisconsin, a stranger who sent a $500 donation after getting a copy of my, my translations that I'm doing. And she's obviously a very spiritual and, deep rooted woman in her spirituality. Then that's why she supported the translations. But if that miracle didn't occur, we'd be shut down right now. But if a bunch of you out there would have worked with just a little bit $5 bill, like Typhoon up in Colorado, thank you again, Ty, we wouldn't have a money problem. It's a little bit, just consider, like a little, once a month, boom, once a month, just like you put it in the basket at your local church, that will go a long way, because it means that we'll be able to add more stream capability. We'll be able to take on 75 listeners instead of 25 or 50. And that's what we're dealing with. And Christian, he don't ever ask, and he lets me pitch it for the network, but really give it some thought, ladies and gentlemen, because we're in tough times, but we all need each other, and we need, just send us a vote, okay, if you could, please. Let's see if we got another question down here. Nobody hitting star 5 with question? I see we got a lot of people on here, and I can't get over it. There's always usually people standing in line. Let's see if we got one on Skype here.
Desert, back to Rhonda's question here. Here's the section that is talking about disclaimer under section 149 on page 38 of the Gilbert's book. Disclaimer or resignation by trustee. That's section 149 for everybody's reference there.
Okay. Yeah, we've got a caller, Charlie in Florida. Go ahead, Charlie. You're on.
Hey, Desert. How are you?
Doing okay. Now hit 6 about 4 or 5 times, Charlie, on your phone. Number 6. And that's going to boost you. Okay. Give it a shot. I'll try to boost you on this time. Hit it a couple more times, please.
Okay.
Yeah, there you go. You're good. Good.
All right. Good. Hey, Christian, how are you?
Great. How are you?
Okay. Good to talk with you again. I just got back. I was listening actually on the cell phone as I was in the car, but I was afraid to get online because it might have cut out, and I'm home now. So Anyway, interesting discussion this afternoon, and I just thought I'd bring this. You might have addressed this before, and if not, maybe there's you can spend a little bit of time with this. But as I was talking to someone today who, we were discussing a lot of the things going on with the trust. He had some knowledge of it, but he had been in contact with Vic Beck over the last couple of years, and his question was, he said, well, if the grantor is the one who's, basically expressing the fact that he is the one putting in the res property into the trust, and if that is coming in, and let's say you're using NOI and SOI, NOI being the UCC1, the transfer being the UCC3, isn't it all done in the name that is on the birth certificate? That is basically owned by the state. Is there any problem that you see that could create? I really didn't know how to answer him on that.
No, that's really just an NOI that they're going to look at everything to be construed as that fiction character. But that's the face mask. That's the definition of legal fiction. That's the face mask, the straw man that you must wear to enter into that realm.
Okay, so you're saying that the grantor is really then that fiction straw man.
Okay, put that face mask on and enter into their public realm and put that NOI in there. Pull the strings of that puppet.
Okay, but in the in-camera hearing and under a protective order, how does the living man appear in that?
Okay, that would be the real self because the judge doesn't have his black robe on. He's just got his regular clothes, acting as a judge now.
Okay,
and under his private capacity.
Okay, so if I'm following this, and correct me if I'm wrong, but if I'm in that in-camera hearing, and like, again, I'm speaking, and he doesn't have the black robe on, speaking as the living man, I am saying I'm using the mask of the fiction straw man in order to enter this res property, which is where the...
No, I would put my real self there. In chambers, I would be my real self. The face mask has been removed. I'm there in equity now as the real man.
Okay, but if the real man makes any reference to his name, isn't that something that's then the property of the state through the birth certificate? Because
I'm not in the public realm, so I'm not going to waive everything in chambers.
Okay,
that's the only the real man has his standing rights is in chambers. And that's where the real man shows up.
Okay, all right. So, but isn't okay? So the real man isn't entering the res property by transfer. It's the straw man or the mask that's being used, but it's basically the real man that's pulling the strings behind that.
Correct.
Okay, and then the judge you believe the judge would understand that, huh?
I think so. Yeah, better than what he gets on. Now we're learning how to manipulate this puppet because you really need this puppet. You need the straw man, but you just need to know how he functions and how to pull the strings. And we haven't learned that yet.
Okay. So if they made any kind of claims to that name that you're using, what would your response be back? Based on that kind of a claim, if they're saying,
well, in chambers there is no evidence to substantiate that claim, so it's an unsubstantiated claim. And there never will be straw man fiction evidence in chambers, and that's why they will never put any in there because they can't cross the line either. Neither can you.
So So the only SOI would be that which I brought in, right?
Correct.
And that's under a protective order. All right, yeah, okay, I see that. And just as a technical issue, because you know a little bit about where I'm at in the process here, and, I'm sorry I have to always use kind of a court setting. I know with a lot of the listeners and other people, it would be better for them to kind of remain out of court if they can help it, but, I'm kind of far down the road here, and so I'm involved in a lot of litigation. But in the case where I'm looking at not being able to compile enough of the SOI, and I have a hearing coming up. Would that be the reason that things could fail? Because I'm coming in there saying, well, I've expressed the existence of the trust, and now my SOI is forthcoming, but it's not all there. I can't help but seeing this judge staring down at his bony finger in my face saying, well, if you brought it up, you should have the stuff for it. If you don't have it, you're out of here. So
Well,
is there anything that can be done, based on that?
You could ask for a continuance.
Yeah.
I don't have the process completed. I need another, say, 30 days.
Yeah.
Or I could come in and do a UCC filing online, and when I get a copy offline of what I filed, that electronic transmission becomes evidence also.
Okay, so I could actually do that, and then even though there could be hard copy following it,
right,
there's enough there to be able to support what I've done.
Right.
Yeah. Okay, all right, well, that's good. I guess I'm just, and again, from a real fundamental standpoint, if there was a situation where the judge was to hypothetically look at me again and say, well, where did you get the claim on this wealth that you're considering is the case number and these other things that you put in? Where are you getting or where are you assuming and presuming that you own that in order to bring it in here to begin with?
Well, first of all, that's outside the pleadings, and that's not on the plate here for this hearing today. Where's that in the pleadings, Your Honor?
I see.
That's not an issue here today. We're here for something else. We're here for breach of trust. And I proved trust. Now I want conclusions based on facts and law. Here's my evidence. Did you read the evidence?
Mm-hmm. Okay. All right, that's good. And I might make the suggestion, if there is, I don't know, in some of the workshops and everything, what would be very helpful to me, I don't know, maybe I can get a constituency, a vote by some of the other people, but some sort of a mock court would be very helpful to me. It has always helped in the past. I don't know whether, because like what you just said, see, is something that would come into a mock court situation, and then it would put me on the spot. I'd have to think on my feet how I would have to respond back if there was a retort that kind of, took me off guard. To me, those are just valuable,
Really?
So I don't know if there's others out there that feel the same way, but those mock court situations could be very helpful.
Right. But it really comes back to basic government. If we understand more how to do basic government, which is, I got to have a hearing to be heard, and the other side has to have a chance to object, cross-examine, and then I got to give notification to all parties. And if we start thinking of everything that the other party's going to say is really nothing more than objection, which an objection is nothing more than an NOI again, and that NOI has to be supported by an SOI in order for that to be granted, otherwise it should be overruled. So an unsubstantiated claim, no matter whether it was an objection or whether you're claiming trust or whatever it is, without any SOIs, it's unsubstantiated, it's immaterial, and it's overruled.
Okay, so if that came up, let's say the opposing party just says, "Well, Your Honor, there's I don't know where this party comes off making any claim to this case and it being part of the res property." My position would be, well, Your Honor, is it not true that I have the notice of interest in the form of a UCC-1 and also the substantiated evidence in the form of a UCC-3? Where does my opponent come off in challenging something that he hasn't made anything on the record to show any kind of evidence?
Case, his objection is unsubstantiated and should be overruled. And I was going to, instead of arguing his accusation,
Okay.
I'm going to drag him back to my side of the case and get him to argue my facts. Bring him back to your facts.
Okay, that's good. I like that. Okay, that makes sense. And on the and in terms of the word based on trusteeship, because I hear a lot of questions coming up on the responsibility and the acceptance of trustee and the capacity, responsibility, and so forth. Does the word constitutor have any synonymous meaning to you in terms of the trustee?
Yeah, it does. Really, they're the constitutors. He's the constitutor. He should have the duty. The rules are for him. That Constitution's for him, and he's supposed to take care of my debts because that's what constitutor is. The one who is supposed to pay the debts of the obligation.
All right, good. And one more question, it's unrelated to this, but in terms of the spendthrift trust, and you may have covered this already, but in studying the spendthrift trust, I guess on one side of it, I was reading, and it looked like, wow, this is great for me, and then I keep reading, and it's like, oh, this isn't so good for me. So, can you expound a little bit on the spendthrift trust in reference to things such as restraint and alienability? That's where I'm not sure. How does it help us, or what should we be careful in terms of the spendthrift trust? How can that be used against us, or how can it be used for us?
Well, the Spendthrift Trust was really a Declaration of Independence formed in 1776 by the reasoning of the Founding Fathers as a protection against the beneficiaries, against any wrongdoing that they might do, and cause the creditors to come at them and get their assets.
Okay.
So it was to protect them so they couldn't be leaned up. And that's just exactly what the Declaration of Independence says. Unalienable rights.
Oh, okay. So we're trying to show the unalienability.
Right. But now they're on our modern view, present time, they're construing it to be different. They're coming under a protective trust and per discretion now.
Yeah. Oh, okay.
So they're construing it, or misconstruing it really, because we never expressed it to be a 1776 Declaration of Independence trust with unalienable rights. So now they're construing it under the modern view, which under the modern view it says that, let me see if I find it quick. Under page 140, the rationale under the protective trust was a protective trust may be intended to reach a result somewhat comparable, and in fact they say more secure than the result of the spendthrift trust, but is logically less objectionable. So they're construing it. In that the beneficiary can be sure of receiving substantial trust benefits. In other words, if you want paid, only as long as he keeps his debts paid. In other words, he's in good standing. He's a good debtor. On the other hand, these trusts are subject to the criticism that they accomplish indirectly what they could not do directly in some states, and then it quotes the bankruptcy code. But there it was. They're saying that this more modern view is less objectionable, because now that we can withhold under the trustee's discretion, under a discretionary trust.
Oh, I see. So, for instance, if somebody had like a federal tax lien or something, that could come under a discretionary position, saying, well, this is a bad debtor, or this is someone that has not, done whatever.
Yeah, we can't let a person do their set-offs and their discharges with their private instruments because it's per our discretion, and we can't let them do that because they don't have the standing to do that because they're debtors. They haven't paid the previous war debt. They haven't paid their present debts. They don't have that ability to do that. Beneficiaries are incompetent.
Okay, so how would you defeat that then? What would be your objection, or what would you say if that was brought to you?
Okay, there's two ways I can play this, and either way I got a win-win situation.
All right.
We've talked about this earlier on the show tonight, that I could come in as beneficiary, but I'm talking about now coming in as trustee. They're under the presumption that I am the trustee. I'm going to come into the court. I'm going to agree with them. I agree with you. I am the trustee. And I'll agree with you that I didn't make a payment, and I'll agree with you that I owe a payment. Now, where's the case at? If there's no controversy because I agree with them.
Okay.
There is no case if there's no controversy. I agree with them.
Right. Okay.
Case is closed.
How did it get paid? How did it get paid, though?
Okay, now let's go into chambers, Your Honor, and I got some secret information I want to reveal to you, and here's what I won't tell him, but this is what I've been thinking. That really reveals why I legally cannot make a disbursement as trustee, because you guys, you beneficiaries, are bankrupt, and I have a discretionary trust, and I'm under discretion of the trust to withhold because you beneficiaries are insolvent.
Okay, so I see what you're saying. So you would be able to say, I have an answer, but in order for you to hear the answer, we have to be in a different venue.
Yes, it's a trade secret information. It is a state secret information. Only for diplomacy purposes can I reveal this in chambers.
Okay, good. I see. Okay, that's real good. Well, thank you very much. I'll leave it open for other questions and stuff. But I sure appreciate everything you're doing, and also Desert, thanks for your help too. And I'm glad that things are up and running again.
Let me make one other caveat. Let's take it one step farther in chambers while we're in there, Your Honor. here's a private instrument to take care of the beneficiary's insolvency, pay his debt, and then when you pay his debt, I'll release all the funds held in trust.
And that instrument could be some sort of a money order, non-negotiable.
Yeah, set-off instrument, yeah.
Yeah, okay. Okay, good.
Bill of exchange.
Yeah, okay. Thanks again. By the way, I just got, I just got the information. I wish I knew more about it, but some people out there may know of the North Carolina cases that 32 counts of use of BOEs, promissory notes, and so forth, totally vindicated, and the jury trial, which found them, not guilty without prejudice. The judgment was they were totally vindicated from the whole mess. So I don't know, I forget the name of it now, but it's very very encouraging.
Well, that'd be interesting. Find out what that is.
Yeah, I'll get the case for you. I'll send it to you, Christian. I'll get it off to you. It's real good. And the transcripts, you can get the whole transcripts, but we have the most pertinent things. Okay, and it came to we're talking about $7-8 million, and the inside information was that the prosecutor, every time they read every 32 counts, he just sighed and he was almost in tears by the 32nd count. They were totally vindicated of all charges, and it was all on BOEs and promissory notes. I'll get the case. I'll send it to you.
Okay. Thanks, Charlie.
All right.
Copy too, Charlie.
Okay. Thank you. Good night.
Okay. Let's see. We got Matt to another follow-up in England. Could Christian explain the counterclaim he mentioned the other night while answering a question from JC regarding the subpoena and summons?
Yeah, that was directly out of Black's Law, 8th edition there, where I read, and we just read it tonight again. It was under the bill, really the definition of bill.
Good. And we got the Hanna family in Wisconsin. Let's see if I can do this one here. I'm hoping this is correct, as Christian Walters said it was by Frederick Levine, and then he's got a website here, www.archive.org.
No, it's not Levine, it's Lewin, Lewin.
L-E-W what?
Lewin.
Lewin, and which is a practical treatise on the law of trust.
Correct.
Trustees. Oh, here we go. We got it right here.
Not on trust.
Lewis.
No, that's a different title. Lewin.
I see. All right, he's got here Lewin Thomas, 1805-1877, a practical treatise on the law of trust and trustees. Will you ask if this is correct?
Not it.
Author, thank you.
That's not it.
Not it.
No, it's not it.
Oh.
Pay attention, people.
All right.
A practical treatise on the law of trusts, quote unquote, period, by Frederick A. Lewin, Lewin, 1888. Let me preach that again. 1888, volume 1 and 2. Got it?
Give out that title again, Christian, one more time of the book.
Put it in quotes. A practical treatise on the law of trusts, unquote.
And no trustees then. There's no trustees on it.
And that's it. That's another book.
Yep.
Frederick A. Lewin, 1888.
There's an easy way to...
Volume 1 and Volume 2.
Remember that year. Yeah.
If you punch it in, if you put that quote, a practical treatise on the law of trust, unquote, you put that in your browser search engine and under Google Books, and it will pop up Volume 1. Download that one, and then do a search again for the same thing, and then this time go past your quotes, and then put in VOLII for Volume 2, and you should get the Volume 2 then. But make sure it says 1888, and that's the title, A Practical Treatise on the Law of Trust. If it doesn't say that, it's not the same book. And you also want to get the one also tying this in with the one on Scots on Trust. He gives case examples of 1919. While you're in there, Google, search for that one. Put in there Scots on Trust, and look for the one that pops up that says 1919. It talks about cases. It gives you case examples in support of this treatise.
Okay, Matt is giving us a heads up here. He says, tell the people to go to www.archive.org and go to text, T-E-X-T-S, text, and they will see it. That's 3ws.archive.org.
Yes.
Okay.
This
Thank
stuff,
you, Matt, England.
This stuff will be available on my website at movingtitles.com very shortly. I will have the download links for that pretty shortly. That's why you want to keep checking the site.
Okay, let's see if we got another question out there. Just trying to save some of this data, sending myself an email here. A lot of good information passes right through your fingertips if you don't write it down. Okay, we got somebody on Skype. Looks like John in England. He just got on board with us here. This is exciting stuff, and there is so much misunderstanding about all of this stuff, all the way including the courts, and justice has become common practice rather than common law. Okay, justice becomes common practice. Okay, and thank you, John, up there, and for your donation as well. He sent the network a donation by PayPal. Thank you so much, all the way from England.
Yeah, keep in mind that trust does not operate in common law. Trust operates in equity. Equity is not common law.
Okay, area code 415. State your first name. Where are you calling from, please?
Yeah, this is Chris Summers, Christian.
Hi, Chris. How you doing?
Chris. In California,
Good.
right?
I had three.
Chris.
Actually, I wanted to comment.
Right?
Hello.
Hey, yeah, you're in California, right?
Yes.
Yeah, got you, Chris. Okay.
I wanted to compliment your clarity is just the best I've heard in quite a while. So compliments to that. I would like a copy of that North Carolina on the BOE so I can post that at Law Learners. That way we've got 5 different cases that were vindicated. That would be the 5th. So when you do get a copy of that, I'll post it over at Law Learners. The questions that I had, the Gilbert's book on trust, what edition is that? It's the most recent one that you're mentioning here.
Yeah, it's the 13th edition. It's the one I have is 2008 copyright.
Okay, and then the second thing I wanted to ask you, in regards to the maritime admiralty liens that we're doing and filing the UCCs, how is it that you're viewing those, and how can we utilize those in an efficient manner or an effective manner?
Actually, they're debtor-creditor liens, but still it can be trust res property. If we treat it as a special deposit after you got your liens, it goes in under trust as trust res. So it would be kind of a hybrid, crossing debtor-creditor along with trust.
And is there any particular recording or reference that we can go back to in your archives to maybe obtain enough information to be able to take that stage or step?
No, I really haven't talked too much about a hybrid, but I've mentioned it here and there, and I don't know exactly where that would be and amongst all the downloads. Somebody else might have some light to shed on that. I don't know if somebody remembers.
The last question I had to ask you, I have been promoting your classes, and inadvertently, I didn't even catch whether or not you had a limitations of people being in your classes. Can you give me a comment in regards to me promoting these classes and what your limitations are with each of the classes?
You mean for size-wise?
Yes.
Size, we can accommodate up to 150 people in the meeting room.
And where are you at right now with the classes?
I would say we're probably up to about 30 right now, I think, people that are...
Oh, okay, so there's plenty of room.
Yeah.
Well, I've already been on the horn since I've talked to you a couple days ago, and we've got quite a few of the researchers' ears perked up. They really want to get in on this, so instead of me continuing to promote it, I had to ask you before I continued because I didn't want people to be discouraged.
No, go ahead. Yeah, it's still, we got plenty of room yet. It's been announced 1 week, so last Saturday was the official announcement of it, and we've got plenty of room yet. But all the information is on the movingtitles.com website. If they just go there, movingtitles.com, just punch that into your browser or do copy and paste in there or type it right in the browser. Don't do a search. It won't come up on a search.
Oh, the books that you were mentioning earlier, along with the Gilbert book, is that basically kind of the requisite books that we can obtain, or is there any other additional type of books that we can obtain that will assist us with our education with you?
I'm trying to put together the website, put all the stuff on the website, so shortly, I just put the website up. It's only been up a week. As you keep checking back, I'm trying to put everything up on there, and then, it takes a while to get things up there myself, so. But the books are the UCC with official comments and the Black's Law 8th edition that I've been using, and probably the Black's Law 1st edition, which we also have under digital copy anyway. So along with the Gilbert's Law,
Chris,
as a requirement to get into the workshop.
Christian, when we get with our web guy this week, we'll get your program, Money Banking and Trust, that program ad on the left on the Saturday program schedule. We'll get that hot. That way, if anybody forgets, your website or whatever, they just go to the program schedule, put their pointer on the your title of your program. That'll go. Then it turns to a hand. They click on it, goes right to the website, and we'll update your email if you want us to change it from Hushmail to your domain name. Then just let us know, okay? Because we'll just keep that stuff current.
Okay. Yeah, the emails are all up also.
You want to go with a different email on the your name on for linking?
Yeah,
Christian Walters.
You could put Christian at movingtitles.com. Yeah, as well as the Hotmail is still active also, or the Hushmail, excuse me, active.
You want me to put both? Okay. Well, your first name will be linked to one, and your second name, family name, will be linked to the other. That way, they got both options. Okay?
Yeah, they could do it either way. Yeah.
Okay, it's Christian Walters at Moving Titles.
No, just Christian.com. Just Christian at movingtitles.com.
Movingtitles.com. Okay, very good. I'll get that this week then to help everybody out. And that's the way it is on our network, ladies and gentlemen. Any of the different hosts we have, typically you can click on their name, it goes to their email, or you click on the name of the program. If they've got a website, it will go to their website. So we're fully interactive with our program schedule. We've actually got the most advanced program schedule in Internet history, and hope you all are enjoying our work over there. Okay, let's see if we have... and Matt again trying to help out with this dial. So thank you to Matt in England. It's really profound to have all of our British friends over there connecting with the network over here. I guess I don't know if they got any gurus over there figuring it out, but it looks like they're having to come over here to get the scoop with Christian Walters.
Hey, Desert Owl, I've got people over in Europe that are looking to join up with people in Europe. If you could pass that information to me, I will most certainly put those people together over in Europe.
Yeah, what do you need now, Chris? The website is therealpublicradio.net.
No. The people in Europe that you're speaking of, I have other people in Germany that are seeking other people to collaborate and work together, and I don't know any people.
Well, listen, I failed to mention
the moving title.
We have a what's that? Well, I just want to mention that we have a chat room, and anyone on this program tonight, there's near 100 people between the stream and the conference line. Anybody can say hello to each other on the chat room. You go to Christian's program ad, it'll say chat with special guests. You click on it, or on any of the programs, we've got it on most of them now. You click on it, it goes to the chat room, and you can be saying hi to Matt in England or to whoever, so that's the way you can connect your programming time. I don't know how else to get you their information, per se, Chris. I'm not too sure. If they want to interact, then that's one way. Or if they want to, I'm not too sure how you want to connect. Try to run that by me again.
Well, I think that would be fine. What I'll do is I'll just give those folks that are looking to make connections over there in the European area to work on mortgage foreclosures. They said they got quite a mess going on over there. And I told them that the conspiracy.com out here had links to people over there. And then I talked to Brian about that, and he says, well, he's lost those links. And so I kind of was left a little bit without anything to get back to these people. But if you say that you've got a chat room that they can join in on a Saturday evening, I most certainly will pass that information to them so they can actually get into the chat and start making contacts.
Well, so send me an email at my email address. I'll put you on our list, and when we announce the next calls, I send out whoever's on the list gets a notification of the next call.
Yeah. I never get on your list, Christian. I can't figure that out. Get me on your list, will you, please? and I want to, Chris, do you want to do a program on the network with law learners? We've got room on Tuesday nights is our vacant night. We're doing 7 days a week of law programming, commercial programming, and we don't have anything on Tuesday right now if you want to join us on the network.
Well, it's highly probable. The reasons why is because all the information that I accumulated last year, Chad, and people are calling me off the wall about the rights to travel issue, and the formula that I've put together in regard to mortgage foreclosure. I've got a couple of the other researchers that are perfecting the formula that we put together, and those things are not quite ready. But, yeah, I'll cater to that idea. I'll talk with you.
Yeah, give me a call on the side. My phone numbers are on the archive and contact page, and my email's there. So just get back with me and let's talk, okay?
Absolutely, I will.
Very good, Chris. Good to see you here. And let me see here. I got Christian. You kind of got interrupted. Were you trying to follow up with a thought?
Well, I was just saying, make sure that you keep me in the loop because, the movingtitles.com is where everything's going to be posted. Everybody's giving out all this other stuff. I'm trying to centralize everything on my website, movingtitles.com. And within time, that's where it's all going to be.
Right. There you go. Well, you got a beautiful website coming up, Christian. Now, Chris, Matt in England says, here you go. Pass my Skype name on to the Europe folks. That's Matt over in England. So, and also my Skype in name, if they want to tag me, is Free America Radio, Chris. That's another way to tag us.
Free America Radio?
Yeah, Free America Radio, one word, here in Kingsland, Georgia. And we've got Sister Soldier, Accepted for Value Part 2 in the UK. What's this, Myra? Accepted for Value Part 2? In the UK? I guess she's giving out a website for general interest, for general info, she says. So thank you, Myra, for that information. And everybody's got a contribution to make here. It's wonderful.
Yeah, well, I think that's great. Christian, I'd be more than happy to send those other cases that we had those folks that were indicted for their bonded promissory notes and that they were actually completely vindicated. I'll be more than happy to forward that to you so you can post that out on your site, too.
Yeah, if anybody wants to know how to get on the site, it's movingtitles.com, and the email addresses for contacting me and for registration, all that is listed right on the front page of that. The home page is there.
Okay. Okay, anybody with any final questions? I'm gonna do a special presentation. I don't know what happened to Soljan Zul tonight, so I'm gonna do probably The Exorcist. I'll give you some symbolism, okay? I'll give you one of my all-time classics, a review of the movie The Exorcist, ladies and gentlemen, coming up next. But just to make sure we cover it, it's really great to not to have to do a program and to accommodate everyone, because I sure enjoy hanging out with all these great people. Everybody, this type of knowledge and information that Christian is presenting is really the most advanced and sophisticated knowledge that you really have to wrap your mind around. So it's very profound to see all these great people out there, around the world and coast to coast here, wrapping their minds around this heavy technology, which is really the true answer, how to get out of Oz and back into Kansas. I guess that's could say it that way, but Kansas.
Well, this is edge technology here. This is the big 60-inch gun.
Yeah.
We're bringing to bear upon the problem. This is the 900-pound gorilla. This is where all the power is at.
Way to go, Chris.
It's really been
power to you.
We really had the power all along. We just never knew it was really trust. We didn't realize that we're wearing trust shoes in Oz. And if we would have clicked those heels together 3 times in trust and right title and interest, which is trust, then we would have been back home in Kansas. So that's
very good.
We're on the ground floor here. We're riding a wave. I mean, everybody's getting in on the ground floor. Instead of rushing ahead and trying to do paperwork and stuff, I've been trying to stick more with basics to more people get an understanding of what we're talking about here. Because really, you're going to need the understanding of the basics in order to take this into court or wherever. And I can envision later on, once we get this down, we don't even have to go into court unless we get hauled in there. Because I'm going to solve it administratively within the IRS, under a Treasury DIB hearing, under 25-06. I'm going to let my big brother take care of all this mess. So I'm about done for tonight.
I guess so, Christian. I don't know. I guess that we don't have any more follow-ups. No more hands are raised. And it looks like we've done our job and damage for the evening. So I want to thank you, Christian.
Okay, we'll take the Nebuchadnezzar back in for hiding until we pop up on Tuesday night. We'll see you there, our Tuesday night show, with the number I gave out.